Get this idea that you're really psyched about my mind.
We could just do 3 videos. I'll pass it over.
Man, you know what? You have some ball says that was Eddie Guerrero's movie.
I know.
But you don't even know who that is.
The pretty good. Chelsea Green. I know.
May I have the bailiff?
All rise. This court of the Lake County Common Pleas is now in session, and the Honorable Judge John P. O'Donnell is now presiding.
All right, be seated, please. All right, are counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Ready for opening statements?
Yes, Your Honor.
All right, for the prosecution.
Good morning, Your Honor. My name is Ahmed Pramani, and today, along with my co-counselor, Noni Mutiso, we will be representing the state of Buckeye. Today, the state will call on 2 witnesses, Frankie Moya, played by Lainey Ryder.
Good morning, Your Honor.
And Detective Ronan Salah, played by Samara Mutaba.
Good morning, Your Honor.
Good morning.
May it please the court. This case is about death, tragedy, and justice. This is a case about the admissibility of evidence. Evidence that will finally bring justice for a man named Caleb Jameson, a man who was strangled dead in his apartment. The defendant, Morgan Remy, to the crime and gives long-awaited closure to a case that remained unsolved for 25 years. In the year 2000, Caleb Jameson's lifeless body was discovered in his apartment. DNA was recovered from the scene and believed to be belonging to the assailants. But at that time, technology could not identify its source. With no additional leads, the case went cold, leaving a murderer on the loose. Years passed, then with advancement in technology, hope was restored. In 2025, a student voluntarily uploaded his DNA to the genealogical website. By agreeing to the website's terms and conditions, that DNA was lawfully included in a database. When law enforcement compared that information with DNA already in their possession from the crime scene, they finally uncovered a lead, one that pointed to Morgan Renemy. After 25 years, justice was finally within reach. Now, the defense argues that this evidence, the DNA in the ring, should be excluded, claiming that the genealogical search violated Morgan Renemy's Morgan Renemy's Fourth Amendment right. But the law and the facts tell a very different story. Your Honor, the state of Buckeye bears a burden here, and we accept it. We must prove by preponderance of evidence, meaning that it's more likely than not that the genealogical search was lawful under the Fourth Amendment, and we will meet that burden. First, we will show that the use of gene heritage data did not constitute a search under the Fourth Amendment because the information was voluntarily shared, consistent with the long-standing third-party doctrine. Second, even if this court determined that the search occurred, the search was still constitutional because it was conducted with valid consent. Consent that was voluntarily given by Frankie Moya, lawfully relied upon law enforcement. To prove these points, the state will call two witnesses. First, we will call Detective Ronan Salah, who will testify his experience investigating hundreds of cases, how the evidence in the case was lawfully collected and preserved, the proper procedure used to acquire the genealogical information, and how every step of this investigation remained within the boundaries of the law. Second, we will call on Frankie Moya, who will testify about how he was informed about the use of his DNA, how he voluntarily submitted his DNA to Gene Heritage, how he gave consent by signing the contract without coercion, and how his belief in the justice system influenced his decision. The Fourth Amendment protects individuals from unreasonable searches and seizures, but it does not prohibit law enforcement from relying on information that is voluntarily shared or obtained with valid consent. Your Honor, by the closing of this hearing, evidence and testimony will make it clear that the information at issue was obtained lawfully and without any violation of the Fourth Amendment. For these reasons, the state respectfully asks that you deny the defendant's motion to suppress.
Thank you. For the defense.
Your Honor, before I deliver my opening statement, can my team introduce ourselves?
Yes, go ahead.
I'm Quinn Linner. I'll be giving the opening statement. I'll be direct examining Ms. Haven Peters and cross-examining Ms. Frankie Moyo. This is my co-counsel.
Good morning, Your Honors, my bad. I'm McKenna Merritt. I will be delivering the closing argument, directing Mr. Val Barak and crossing Ms. Ronan Saleh, and the witnesses will introduce themselves.
Okay.
Good morning, Your Honors. My name is Ruck Eckert, and I'll be portraying Val Barak.
Good morning, Your Honors. My name is Leah Niemer, and I'll be portraying Haven Peters.
All right, thank you.
Your Honor, do I have permission to move the podium?
Go ahead.
It's heavy. May I proceed?
Go ahead.
Opposing counsels, Your Honor, and may it please the court. Ms. Frankie Moyo saw an exciting and interesting opportunity to take a DNA test for a school extra credit assignment. Months later, she received a phone call from someone who had never crossed her mind, the Harmony Police Department. This college freshman was plunged into a police investigation years old of which she had never heard. The police had taken her DNA from the testing website Gene Heritage and used it in this police investigation. Prior to a phone call, Ms. Moyo had no intent of this ever happening, nor did she ever be informed of the police taking her DNA. Therefore, Your Honor, she could not have given her consent to this search because consent begins with intent. As you may have noticed, Your Honors, I have not yet mentioned the defendant, Mr. Morgan Remy. This is because Mr. Remy had nothing to do with Ms. Moyo, her school projects, nor the police's obtaining of the DNA. Clearly, neither he nor Moyo had intent nor had been informed. The burden of proof today lies with the prosecution, who, by a preponderance of the evidence, must prove that either A, the consent exception applies, or that B, the third-party doctrine undermines the reasonable expectation of privacy. Now, the consent exception holds that if someone willingly gives up information with no coercion, well then, that information is no longer protected. But the consent exception does not apply over material seized from a third-party relative. This would require the third-party doctrine, which holds that in giving up information to a third party, as in not the government, one is then no longer allotted privacy as that information has been made public. However, neither Mr. Morgan Remy nor Ms. Frankie Moyo had given up any sort of information to any third party. What Ms. Moyo had given up was biological matter that anyone would agree must be private and protected. Since Gene Heritage never owned Ms. Moyo's DNA, they merely stored it. The obtaining by the police of her DNA was unconstitutional and a violation of the Fourth Amendment. The Fourth Amendment, Your Honors, a pillar on which this nation stands, maintains that there shall never be an unreasonable or unwarranted and unconsented to search and seizure. Cass v. United States sets up a two-pronged privacy test. Number one, the person must expect privacy, and number two, in the same situation, the reasonable person would also expect privacy. So for this, you'll hear from Mr. Valbarak, who will testify that he was in the same class as Ms. Moyo and withheld giving his DNA to any of these websites out of fear of a potential police use. Then you'll hear from renowned journalist Ms. Haven Peters, who will testify how websites like Gene Heritage might trick their users, and how failing to uncheck a box is so much different than willingly consenting to a police search. Now, the prosecution will try to argue that Ms. Moyo willingly gave her DNA to Gene Heritage, so she willingly gave it to the police. But let's look at a similar situation. In Timothy Carpenter v. the United States, police wiretapped phones without a warrant. They then used information from those wiretapped phones to arrest Mr. Carpenter. The court ruled that just because Mr. Carpenter gave information through a third party, the telephone line, it did not make the warrantless obtaining of that information legal. Therefore, at the end of this proceeding, my co-counsel will ask you to rule in favor of the defendant, Mr. Morgan Remy, to rule a Fourth Amendment violation and withhold the evidence at hand today. Thank you.
Thank you. Will all those who intend to testify please stand and be sworn in by the bailiff? All right, would you raise your right hand? All right, I'll give the oath. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, as you shall answer to God? All right, be seated. Call your first witness.
Thank you, Your Honor. We'd like to call Mr. Ronan Saleh.
All right, I would just ask you to stay close. You can turn that microphone down toward you. Just stay close to it, okay?
Okay. Please state your name and occupation for the record.
My name is Detective Ronan Saleh, and I work for the Harmony Police Department.
How long have you been with the Harmony Police Department?
I have been with the Harmony Police Department for 35 years.
Can you describe your current role within the police department?
My current role is the lead investigator at the Harmony Police Department.
And for how long?
I've been there now for over 20 years, since 2005.
What is your understanding of the case that brings us here today?
This case involves the homicide of C.J. Jansen, which took place in 2003 and went unsolved for nearly 2 decades, up until 2018, where new forensic tools were available and the case was reopened and then solved.
When you began your review, what stood out to you about the original investigation?
From the original investigation, although it was very well conducted and well documented, it did come to a standstill due to the lack of forensic tools that were available at the time.
What physical evidence was preserved from the original scene?
From the original scene, we were able to obtain a gold signet ring along with DNA under the victim's fingernails.
Why was the DNA not fully analyzed at the time of the original investigation?
The DNA was analyzed and entered into CODIS at the time. However, there were no direct DNA matches, so it was unable to be recognized.
What is CODIS?
CODIS is a secure FBI database used by law enforcement agencies, and it takes DNA samples from crime scenes and matches it with DNA profiles that are already uploaded.
Thank you. Procedurally, what steps did you take to ensure to preserve the privacy rights of the citizens?
We obtained the DNA sample from the crime scene, and then we uploaded it into CODIS. And once we uploaded it into CODIS, we looked for a match, and we were unable to find one. But once we got the new forensic tools, we uploaded it into that, and we also always got a warrant when needed to move forward.
Can you explain what forensic genealogy is in simple terms?
Objection, Your Honor, pursuant to Rule 708. Ms. Saleh can't, opposing counsel hasn't laid any foundation that Ms. Saleh is an expert in, what was the question? What did you ask her?
Can she explain forensic genealogy in simple
Yes,
terms?
Mrs. Saleh has not been testified as an expert in forensic genealogy.
And your response to that objection?
She has worked with forensic genealogy since 2018, so she is familiar, and she has used it to solve hundreds of cases.
All right, thank you. The objection's overruled. Go ahead.
Yes, Your Honor.
May you please explain forensic genealogy in simple terms?
Forensic genealogy uses DNA that has been uploaded with consent, and it looks for matches with similar relatives, and once that happens, you find a match and you move forward.
In this case, how did you determine the family background to search? Let me rephrase. In this case, how, from the sample of DNA that you collected, how did you identify Morgan Remy's family line as the one to search?
We got the DNA sample from under the victim's fingernails, and then once we uploaded it into the genealogy database, we were able to create a family tree and rule out other suspects that didn't match the profile that we were looking for.
Did you later obtain a DNA sample from the defendant?
Yes, we did. And the sample was obtained with a warrant.
What was the result of the direct DNA comparison?
The result was a 100% match with the suspect, Morgan Remy.
Beyond the DNA, did any additional evidence connect the defendant to the investigation?
Yes, we had a long list of employment records and a in-work dispute with the suspect and the victim.
Based on your entire investigation, did the evidence consistently point to the same individual?
Yes, it did.
All the evidence taken together consistently pointed to the exact same individual?
Yes, all the evidence pointed to the same individual.
Do you believe the evidence you collected in this reopening reliably identifies the defendant?
I do believe that this evidence reliably identifies the defendant.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honors. May I proceed?
Go ahead.
Good morning, Ms. Saleh. I'm McKenna Merritt. I'm just going to ask you a few questions based on that direct examination you just gave. So, Ms. Saleh, you are employed with the Harmony Police Department.
Yes, I am.
And in fact, you're in the cold case division.
Yes.
And you are aware of the company Gene Heritage.
Yes, I am.
In fact, you utilize Gene Heritage.
Yes.
And you upload these cold cases you're given into Gene Heritage.
Yes, we do.
And once you uploaded these cold cases into Gene Heritage gave you a disclaimer that they can't guarantee 100% accuracy for samples they did not collect, correct?
Yes, but we don't only rely on Gene Heritage. Yeah.
But also when Gene Heritage also gave you another disclaimer saying that samples they did collect or that are from their lab are also not 100% accurate.
Yes.
And you just said you would not solely rely on Gene Heritage to make an arrest,
Yes.
but you still utilize Gene Heritage as a resource to possibly find a suspect.
Yes.
So you uploaded Frankie Moyo's DNA, or you got Frankie Moyo's DNA from Gene Heritage, correct?
Yes, we did.
And at first you didn't get a match with the DNA.
No.
Right, but then later down the line it matched to Morgan Rim.
Yes.
And Frankie Moyo's DNA contained more than just their DNA, correct?
Correct.
It contained their ancestry, medical traits, sometimes maybe some personality traits.
Yes.
And so you were able to build this whole entire family tree just based on this one piece of DNA, correct?
Correct.
And these family members in this tree, you never received explicit consent from them to have all their information, correct?
Correct.
And you never notified the family that you had all of this information from their family tree, correct?
Correct.
And you never notified the family that all their information was even part of a criminal investigation, correct?
Correct.
Thank you, Your Honors. No further questions.
Thank you. Is there any redirect examination? No?
No, thank you.
All right, you may step down, thank you. And please call your next witness.
We call Frankie Moyo.
Step forward, please, and take the witness stand.
Could you please state your full name for the court and tell us a bit about yourself?
My name is Frankie Moyo. I'm currently a freshman at Buckeye State University.
Can you describe your academic interests and what you were involved in academically?
I am interested in chemistry, biology, and forensic science, and I took a forensic science class in college.
You understand you're a witness at this hearing today because of DNA sample you submitted to Gene Heritage.
Yes.
Can you explain the extra credit opportunity and what was required for the extra credit opportunity?
It was an extra credit opportunity in my forensic science class taught by Bailey Kim, and we had to upload our DNA sample to a genealogy website and write a 3-page summary about the results.
Was the assignment optional?
Yes, it was.
Was the extra credit opportunity required to pass the class?
No, absolutely not.
Did anyone pressure you to do the assignment?
No, it was totally optional.
So what were your reasons for doing the assignment?
So my grades were always extremely important to me, and I really wanted to pass that class. As I've said, I'm really interested in forensic science. Also, I'm adopted, and I wanted to find out more about my biological family. And I've also heard that I could find out more about chronic health risks through these websites.
And to be clear, you were required to submit your DNA sample to Gene Heritage to get the extra credit.
Exactly.
Did you have multiple websites to choose from?
Yes.
Could you explain why you chose Gene Heritage?
Because it was for free.
At the time you submitted your DNA, you were capable of making your own decision.
Yes, I was over 18.
Objection, Your Honor. Opposing counsel's question is leading pursuant to Rule 611C.
Any response?
Can I rephrase my question?
Or rephrase your question? I'll sustain the objection, rephrase your question. Go
Yes, Your Honor.
How old were you when you signed the contract?
19.
Did you sign up for an account with Gene Heritage?
Yes, I made a profile.
How did you do that? Did you receive terms and conditions when you signed up for the account?
Objection, Your Honor. Pursuant to Rule 611C, this question is leading.
All right, the objection's overruled.
Yes, Your Honor.
Could you repeat that?
Did you have to review the terms and conditions when you signed up for your account?
Yes, I did, and I agreed to all of them.
And did you sign the agreement on the first page?
Yes, I did.
Or were you required to scroll through the terms and conditions before you could indicate your agreement?
Yes.
And did you sign up to the agreement on the second page?
Yes, I signed all of it.
Did you scroll through the page as well?
I scrolled to the very bottom. I had to do it in order to move forward.
When you went back, what did you notice about the second page of the agreement?
I noticed that it was about law enforcement, and I agreed with all of it.
What did you receive from Gene Heritage after submitting your DNA sample?
I received the results,
What did the report tell you about the DNA sample?
that they had found a 25% match with my DNA sample, meaning an aunt or an uncle or a grandparent.
Did you do anything more with the Gene Heritage after you received those initial results?
Yes, I paid for the upgraded version of it because they told me that I had a risk of inheriting a life-threatening disease, but they wouldn't tell me which life-threatening disease that was, so I paid for the upgraded version.
Who told you about how your DNA sample had been used?
Mr. Detective Ronan Saleh.
What did they tell you?
He told me that it had been used in an investigation to solve a murder case.
What was your reaction to that?
When I first heard about it, obviously I was kind of overwhelmed, but looking back on it now, I'm extremely proud. With my help, the police was able to solve a murder case. The murder otherwise would have been on the free loose. It would have been among us freely.
And why is law enforcement so important to you?
Because I believe in justice.
Based on the results you received from Gene Heritage, did you accomplish your personal and academic goals?
Absolutely. I was able to contact my biological family and get to know more about them. And academically, I have a lot to write about now in my summary.
Based on everything you described, how would you characterize your decision to allow your DNA sample to be used by law enforcement?
I am very happy about it, and I would always choose to do it again.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Go ahead.
Good morning, Ms. Moyo. My name is Quinn. I'm going to be asking you a handful of questions today. You're currently a college student, correct?
Exactly.
And you've taken a couple of classes in forensics,
Yes.
one of which was in high school. This was a dual credit class,
Mm-hmm.
and that class was particularly difficult, correct?
Sure.
So you needed a bit more work to get your grades up?
Not really.
No? So there was no need for extra credit or anything?
My grades are extremely important to me. That's why I took the extra credit. I wanted to pass the class with an A, but I would have passed the class otherwise as well.
Right, and your grades are important because there's a specific job you want, right?
Yes.
Objection. Relevant.
Yes, Your Honor. I'm merely building foundation towards the reasons Ms. Moyo sent in her DNA. Relevance is a very low bar, so the foundation can uphold this bar.
All right, the objection's overruled. Go ahead.
You want a job as a lab technician, correct?
Yes.
Now, the professor of your class that you took in high school was Professor Bailey Kim, correct?
Correct.
And she assigned that extra credit assignment?
Yes.
Now, when you did this assignment, it was for the academic purpose only, correct?
More or less. I also wanted to get to know more about my biological family, so also personal matters.
But you had no thought of law enforcement, right?
Not at the time, no.
No, and your Professor Kim never mentioned law enforcement at all, did she?
Not when talking about the extra credit assignment, but we had learned about it in class.
So the thought of the Harmony PD never crossed your mind until the phone call, we can agree?
Yes.
Now, Your Honor, would you please let the record reflect I'm presenting 4 clean and unmarked copies of what has been previously designated as Exhibit D to opposing counsel.
Okay.
Would you like me to flip them? Would you like a copy, Your Honor?
Go ahead.
Would all Your Honors like a copy?
We just need one. Okay. Thank you.
May I approach the witness?
Yes.
Ms. Moyo, do you recognize this document?
I do.
And what do you recognize it to be?
The Gene Heritage report.
And you're familiar with this?
Yes, I am.
It has a disclaimer on the back, does it not?
Yes.
Now, I'm going to read this disclaimer, Your Honors. I'm here, the third line down, the second sentence. Please read with me silently as I read aloud. Notwithstanding these efforts, no genetic testing process can warrant or guarantee complete accuracy. Did I read that correctly?
Yeah.
The results contained in this report are provided as is for informational and educational purposes only and are not intended to be relied upon for medical diagnoses, treatment, employment, insurance, legal determinations, or any other decisions of personal or financial consequence. Did I read that correctly?
Yes.
You can put that aside, Ms. Moore. I'd like to talk more about this phone call. Detective Sala called you, correct?
Correct.
And the detective told you that you were accepted into an internship program
Yes.
and you were being considered for the position that you wanted.
Yes.
She also asked about your DNA from Gene Heritage.
Could you explain that?
Yes, she talked to you about the police obtaining your DNA from Gene Heritage.
Yes.
And we can agree that Detective Sala really made it sound like your acceptance into your position was contingent upon letting the police use your DNA.
Objection.
Basis?
Narrative, making it seem like she had bias when something that's false. Making the assumption of that she did it just because detective indicated that she would have more of a chance of acceptance.
All right, response?
Yes, Your Honor, I'm asking this witness a question. If she would like to agree or disagree with me, she is free to do so.
All right, the objection's overruled. Go ahead.
Would you like me to re-ask the question?
Yes, please.
We can agree that Detective Sala made it sound like your acceptance into your position was contingent upon you allowing the police to use your DNA.
No, she didn't make it sound like that.
No, but she did tell you that you were being considered for your position.
Yes.
And she did tell you that she would, quote, see what she could do for you.
Yes.
And then subsequently brought up your DNA match.
Yes, but it didn't feel like one influenced the other.
And right away she asked if you would support the Harmony PD here.
Yes, and I told her I absolutely do.
No further questions, Your Honors.
All right, is there any redirect examination?
Yes.
Go ahead.
Okay. To remind the court, you signed both of the agreements, correct?
I signed all of them. I agreed with all of the terms and conditions willingly.
And just remind one more time that nobody forced you into doing this, correct?
Nobody forced me. It was my free will.
And also that before she approached you, you had an interest in law enforcement.
Yes, I always did. I believe in justice.
No further questions.
Any recross examination?
Yes, Your Honor, briefly. Ms. Moyo, you never specifically opted in to sending your DNA to the police, is this correct?
That's correct, and I never opted out.
No further questions.
All right, you may step down. Thank you. All right, is the defense ready to proceed?
Yes, Your Honors. The defense calls Mr. Val Barak to the stand. May I proceed?
Go ahead.
Please state your first name and spell your last for the court.
My name is Val Barak, B-A-R-A-K.
How old are you, Val?
I am a 20-year-old sophomore at the Buckeye State University.
What is your current occupation?
Well, I'm not currently employed. I'm studying to become a public defender and will hopefully attain that goal by going to the Queen City University College of Law.
Why do you want to go to Queen City
Well, I mean, it's the best law school in the whole entire state of Buckeye.
And how are you preparing for law school?
Well, I mean, besides my grades, I have my internship with the Cardinal County Public Defender's Office, my involvement in BSU's Innocence Project, and my junior level public policy class. But I don't want to leave anything up to chance. That's why I take my grades very, very seriously.
You mentioned an internship. How were you able to secure this internship?
I was able to secure this internship through a recommendation letter written by my professor, Bailey Kim.
Who is Professor Bailey Kim?
She taught my forensic science class at Buckeye State Community College.
How do you feel about Professor Kim?
Well, I mean, we're still in close contact today, even after finishing the class. But I mean, that doesn't really mean our class was necessarily easy. That's why she offered an extra credit opportunity.
How was this forensic science class?
Professor Kim can sometimes be a difficult grader or have difficult subject matter, and that's exactly why she had that extra credit assignment.
What was this extra credit assignment?
Well, all you really would have had to do was simply stick a cotton swab in your mouth and then send it to some random forensic science lab. That sounded way too easy for someone like me, so I decided I would look into it a little bit.
What did you find in this research?
Well, after printing out Gene Heritage's terms and conditions, scouring through all of them, and highlighting through them, I was able to figure out how they were funded.
May the record reflect I'm showing opposing counsel 4 cleaned and unmarked copies of what has been previously admitted as Exhibit B,
Yes.
Gene Heritage's terms and conditions. Would your honors like a copy?
Just one copy, please.
May I approach the bench?
Yes. Thank you.
Thank you very much.
Mr. Brock, do you recognize this exhibit?
I do indeed. This is Gene Heritage's terms and conditions.
And how many pages is Gene Heritage's terms and conditions?
Well, if we flip through in here, this is 1, 2, and 3 pages.
And may the record reflect I'm showing opposing counsel 3 clean and unmarked copies of what has been previously admitted as Exhibit C, Gene Heritage's law enforcement policy.
Record shall so reflect, yes. One copy, please. Thank you.
Thank you again.
And Mr. Barak, do you recognize this exhibit?
I do. This is Gene Heritage's law enforcement use policy.
How many pages is Gene Heritage's law enforcement use policy?
This one is 2 pages.
How many pages is that in total?
Well, after reading through the terms and conditions and then reading through the law enforcement use policy, you have to go through 5 whole pages of that stuff.
How long did it take you to read all that?
Oh my goodness. I don't even know if I could put it into like man hours. It took me so long to do all that research.
And after all that reading and research, how is Gene Heritage funded?
Well, I mean, even after going through the terms and conditions, I still couldn't figure it out. I had to put in extra hours online, and I was finally able to figure out that Gene Heritage is funded through private philanthropy and public safety grants, where basically they sell your DNA to the government and then they receive money for it. And that doesn't sit quite right with me.
How else were you informed of Gene Heritage's law enforcement agreement?
I mean, I certainly wasn't informed other than reading through the terms and conditions myself. I mean, Professor Kim certainly didn't tell any of us in class.
Then why did you not participate in this extra credit assignment?
I mean, along with my concerns with the private philanthropy risks, I happen to be very knowledgeable on cases involving mishandled DNA.
Why don't you want to submit your DNA to law enforcement?
I mean, it's not like I want to be looked at as like some criminal or anything. It's just, again, I have a lot of experience with mishandled DNA through my involvement in BSU's Innocence Project, and that's the whole reason I got into my junior level public policy class, was writing on experiences such as these.
How do you have experience on this mishandled DNA?
Well, I mean, I was first introduced to it through the pre-nuts legal conference where there was this speaker who gave this amazing testimony on how she lost her whole entire life to mishandled DNA. So that, I mean, just scared me.
And back to Professor Kim's class. How was your grade at the end of this forensic science class?
I mean, it was definitely high, but it would have been higher if that extra credit assignment didn't even exist. See, Professor Kim grades on a curve, and because almost everyone in the class did the assignment except for me, my grade ended up being lower than it should have been.
How did you feel about that grade?
I mean, I was mad. I mean, I take my grades very seriously, and being a lawyer is all I want in life, and to, have my grades lowered because I didn't do an assignment, it's dumb.
I'm so sorry, Mr. Barak. Thank you, Your Honors. No further questions.
All right, thank you very much. Cross-examination?
Good morning, Mr. Barak. My name is Ahmed Parwani. I'm going to ask you a few questions today. So, first off, Mr. Barak, you are a pre-law student who plans to become a public defender, correct?
Yes, that is correct.
So your education level is only of a pre-law student, correct?
Yes, I'm a 20-year-old sophomore.
And while you were doing your research, it was as a pre-law student, correct?
Yes, but I mean, all I was really doing was looking through the terms and conditions.
Professor Kim let you have multiple websites to choose from, correct?
That is true, but Gene Heritage was the only free one, and being a poor college student, that was the only one I could really afford.
But he didn't specify any of the other terms and conditions, correct?
Of the other websites, no.
And are you aware of how much that extra credit opportunity actually added to the percentage of each classmate?
Well, I mean, certainly can't remember because, again, I didn't do the extra credit assignment, so it wasn't really worth my time to check.
Was the extra credit opportunity optional?
Yes, this extra credit assignment was optional.
Would you agree that people need to read information provided to make an informed decision?
Oh, I mean, absolutely. After I shared with the class my privacy concerns, that's kind of when it dawned on me that nobody had even really read over the terms and conditions in the first place.
You will agree that failing to read a contract does not mean a person was forced into signing a contract.
I mean, it kind of can be, because what if they don't read something that they don't agree with and they sign the contract anyway?
And not reading means that they were forced?
I mean, if they don't read and then they sign it, they kind of they're binded to that agreement. They are kind of forced.
And you read all of it carefully and highlighted notable parts, correct?
Yes, I did do that to Gene Heritage's terms and conditions, and that's exactly why I decided not to participate.
And after that, you came to an informed decision Gene Heritage was untrustworthy, you should not commit your DNA to it, correct?
Absolutely.
You're concerned based on general policy worries and not specific facts about investigations of Gene Heritage, correct?
Sorry, could you repeat that for me?
Your concerns are based on general policy worries, not specific facts about Gene Heritage other than funding, correct?
If you're referring to the police having my DNA, not particularly. I'm not worried about that. But yes, I am worried about the ways that they are funded. And, since they're a private philanthropy company, if someone took over and I agreed to give them my DNA, what would happen to it then,
And you don't know what safeguards were used by law enforcement yet, correct?
No, I do not.
Would you recognize the agreement if I showed it to you?
Sorry, could you
Would
repeat?
you recognize the agreement if I showed it to you?
Yes, I would.
I'm showing an unmarked copy of Exhibit C to the opposing counsel.
No objections, Your Honors.
Honors, would you like a copy of Exhibit C?
Yes, one copy, please.
May I approach you with?
Yes.
I gave you both. This is the agreement you received, correct?
Yes, thank you.
There are two separate agreements, right?
Yes, there's the one to Gene Heritage's terms and conditions, and then there's the one to the law enforcement use policy.
There's a title on the top of the page. What does that read?
The title, the Gene Heritage Law Enforcement Use Policy.
How many clauses are there?
There are 9 total.
Could you read the title of the first 3 clauses with me?
Definitions
Scope,
of law enforcement access,
Users
and opt-out rights.
so with the first 3 clauses, it informs you that there is an opt-out right, correct?
Yes, that is correct, but first you'd have to navigate to the law enforcement use policy in the first place.
The second agreement is shown to you as a second agreement entirely, correct?
Yes, that is true, it does show that.
And that title said law enforcement on it, correct?
Yes, but again, you'd have to find it first.
The agreement is presented to you after you agreed the first one. You don't have to scroll down. After you agreed the first agreement, it's presented to you.
Oh, yes, that is correct.
And just by the title of Gene Heritage Law Enforcement Use Policy, you can indicate that it's some sort of law enforcement used when signing up to the second agreement, correct?
Yes, that is correct if you read that.
No further questions, Your Honor.
All right, thank you. Any redirect examination?
Yes, Your Honor. May I proceed?
Yes.
Mr. Bullock, why did you just not opt out of Gene Heritage's law enforcement agreement?
Well, I mean, again, it was like I explained earlier, because Gene Heritage is funded through private philanthropy, if I, signed up and opt out and gave Gene Heritage my DNA, what would happen if someone took over the company? What if they wanted to sell my DNA? I wouldn't be okay with that. That's why I decided not to participate.
And why not just use one of those other companies offered to you that costs money?
Well, I don't have enough money to go to one of those other DNA testing websites.
Thank you, Your Honors. No further questions.
All right, any recross examination?
This is the Gene Heritage Exhibit C on hard copy. May I approach the witness?
Yes.
You said if someone took over the company that they could use your Gene Heritage information, correct?
Yes, that is correct.
Could you read all of the user opt-out right?
Users may elect to exclude their profile from LEU matching by submitting a completed law enforcement opt-out form with their sample. If a user submits the form after their sample is processed, the opt-out will be applied prospectively, but any prior matches already reported to LEUs cannot be withdrawn. Opt-out is sample-specific. Each new sample requires a new form.
So this indicates that even if someone takes over the company, beforehand you still have the right to opt out at any time you'd like, correct?
Objection, Your Honor. Outside of scope of redirect.
Your response?
She was talking about if someone could take over the company, they could use the Gene Heritage information. I'm simply stating that if you would have opted out before someone would have taken over, you could have easily gotten the DNA information out before they would fully take over.
All right, I will overrule the objection. Go ahead.
This is talking about the law enforcement use policy, so it's saying you can opt out of law enforcement use, but the company still has to collect the data so that way it can do its research on it.
But they cannot use it for law enforcement reasons. A law enforcement means if you opt out, correct?
Yes, they can't use it for law enforcement use, but they can use it privately, which is what I'm also worried about.
No further questions. Thank you.
All right, thank you. You can step down.
Thank you.
And call your next witness.
Your Honor, at this time, the defense calls Ms. Haven Peters to stand.
All right, step forward, please.
May I proceed?
Yes.
Good morning. Ms. Peters, would you please state your name and spell your last just for the record?
Yes, my name is Haven Peters, Peeters.
Ms. Peters, what is your educational background?
I have a Bachelor's of Arts in Broadcast Journalism from Buckeye Northern University and a Master of Fine Arts in Narrative Media Writing from the Buckeye State University.
Are you currently employed?
Yes, I am. I'm an independent journalist, and I run the podcast Reasonable Doubt.
What inspired you to begin running a podcast?
Well, I've always been interested in the world of true crime, which made me want to start my journalism career. And hearing the ethics of social media made me want to put a stop to the misinformation and set the record straight. This led me to starting my podcast.
What kind of topics do you cover on this podcast, Reasonable Doubt?
I cover media ethics, crime, and forensic science, something for which I'm very fascinated. As I've stated before, there's a lot of misinformation out there, so I like to make sure that my episodes are purely educational. And one even won a Webby Award, or success for Webby Award for success on the internet, in the crime and justice category. And the following year, one was nominated for Best Individual Episode Webby, and this was titled The Dark Side of Genetic Genealogy.
Could you about estimate the size of your platform?
Well, I won a Webby Award, was featured in a BuzzFeed article, and was nominated for Best Individual Episode Webby. So based on this, I guess I'm somewhat popular.
You previously mentioned an episode on genealogy. How did your audience react to this episode?
Well, in 2024, I uploaded the episode titled The Dark Side of Genetic Genealogy, and it was nominated for Best Individual Episode Webby. And based on this, I believe I'm very familiar with the outcomes of genealogy.
How do you go about learning about genealogy?
Lots and lots of independent research. I like to make sure that my episodes are free of misinformation, so I take the extra steps to be extremely thorough.
How do you use that knowledge in your professional life?
Well, aside from my own podcast, I've been invited onto several other podcasts as a leading advocate, and I even testified in the state courthouse in support of HB 12.
Could you please summarize for the court the reasoning behind HB 12?
HB 12 is a bill that cements the right to your own privacy.
Your Honor, would you please let the record reflect I'm presenting opposing counsel 4 clean and unmarked copies of what has been previously designated as Exhibit A. Would you like me to flip through them? Would your honors like your copies?
Just one copy, please. Thank you.
Thank you.
Ms. Peters, do you recognize this document?
Yes, I do.
What do you recognize it to be?
It is the testimony in the sponsoring legislator in support of HB 12.
Have you read it?
Of course I have.
Why were you asked to testify in support of HB 12?
Well, I believe it's because of my knowledge. I'm very familiar with the outcomes of genealogy, and I have many, many episodes covering the basis of genealogy.
Why is it so crucial to you that HB 12 gets passed?
Well, the fact that HB 12 is even a bill shows the importance and that people want the right to their own privacy.
Would you please tell this court, Ms. Peters, what you know about genealogy?
Well, when you upload your DNA into a genealogy website, the site compares your DNA, your genetic code to others in its database. So even a partial match, like a distant cousin, can lead to family ties. My research has informed me that genealogy is science exploited by law enforcement and performs without meaningful oversight. When police use this evidence to investigate relatives who have never agreed to anything, much less consented to it, this raises many concerns and can lead to adverse and unavoidable impacts.
At this time, Your Honors, the defense would like to tender Ms. Haven Peters as an expert in investigative journalism with a focus on criminal justice.
Is there any response from the state? Right. She's admitted.
Thank you, Your Honor. Ms. Peters, you had previously mentioned adverse impacts of genealogy. Could you please tell us about those adverse impacts?
Genealogy leads to surveillance, false suspicion, or worse. For example, a case in 2014 when a man named Michael Usry was being investigated for a partial match on Ancestry.com. Without this partial match, police had nothing else that would lead to suspect his involvement. He spent 3 weeks detained, and in this time, his personal and professional life were ruined. His name was being dragged through the mud, and by the time he was released, it was too late.
How might genealogy impact other cases?
Police were investigating a man named Richard Knapp when his DNA was found on a discarded cigarette butt. From this, the police detained him for 3 years. During these 3 years, his wife passed away, he lost his professional and personal life, and in the end, he lost his house. And both of these cases show the collateral damages that could happen.
How might these damages look for someone who deals with a website like Gene Heritage?
Well, even if you did not commit the crime, both these cases show what could happen. Also, Gene Heritage uses an opt-out system rather than an opt-in. So the reasonable person doesn't even realize what they are consenting to. And for me, this raises many constitutional concerns.
And in your expert opinion, why does this raise a concern?
Police surveilling you, your home, waiting for you to discard something in a public setting like in the Richard Knapp case is not transparency. In the time you stand by waiting for your name to be cleared, your life can be unduly harmed.
No further questions, Your Honors.
Thank you. Cross-examination.
You're a journalist and a podcaster, not a law enforcement officer, correct?
Yeah, that is correct.
You have never worked as a forensic scientist or DNA analyst, correct?
Not exactly, but I research it daily.
Your work focuses on criticizing true crime media and law enforcement practices, correct?
I wouldn't say so. I wouldn't say that I criticize. I would say that I inform the people.
You have described yourself as a leading voice, warning about the dangers of genetic genealogy, correct?
Yes, that is correct.
You have publicly testified in support of House Bill 12, correct?
Yes, that is correct.
So you're advocating for changes to the law in this area, correct?
I'm testifying for the right of privacy, which I believe that we all deserve.
You were not involved in the investigation of C.J. Janssen's murder, correct?
That is correct, yes.
You have never reviewed the police records from the original case, correct?
I've never reviewed them, but I am here to testify of what I know about genealogy, not about this case.
You claim that law enforcement has historically needed a warrant or probable cause to collect DNA, correct?
Yeah, of course.
So, you're aware of the physical evidence collected in the case, correct?
Yes. I'm not exactly sure about the case, and I'm not exactly informed about it.
You're not informed on the case, correct?
Not exactly, no.
On the physical evidence on the case that you are researching?
Yes, that is correct.
So you are informed of the physical evidence or not?
I am informed, yes.
So you're aware of the gold signet ring it found at the original scene, correct?
I'm not really sure what you're asking.
You are aware of the physical evidence collected in the original case, correct?
I am not exactly informed about this specific case, but I have been researching other cases. I think that's where you're confused.
Interesting. So, you have never spoke to the detectives that investigated this case, correct?
That is correct.
So you do not know what steps law enforcement investigated in this case, correct?
Not in this specific case, but in many other cases.
And you have no personal knowledge of the warrants or any warrants that were obtained in this case, correct?
Not this specific case, no.
Okay, the cases you discussed were Michael Ursay Jr. and Richard Knapp, and they're completely unrelated to this case, correct?
They are completely related. All of these cases use genealogy in the investigations.
But did those cases involve Gene Heritage?
Ancestry.com, like used in the Michael
Did-
Usry case, is
Did the cases involve Gene Heritage, yes or no?
not Gene Heritage, but
Thank you.
genealogy
Thank you. That is
websites.
enough. Thank you. Neither case involved Morgan Remy or Frankie Moyer, correct?
That is correct.
So those examples do not describe what exactly happened in the case, correct?
They are very similar. They all use a genealogy website.
No law enforcement officer forces people to submit DNA to these companies, correct?
That is correct.
When someone submits DNA to a private company, not directly, they submitted it to the company, not the police, correct?
Gene Heritage states that they send it to the police when
But
you
it is-
agree.
That company, not law enforcement, controls the data, correct?
Sorry, can you restate that?
The company, Gene Heritage, controls the data input from the private citizen, not law enforcement, correct?
Yes, that is correct.
Thank you. House Bill 12 has not been passed into law, correct?
No, but it is a bill that is in motion.
Your testimony reflects what you believe law should be, not what it actually is, correct?
Yes, but the fact that this bill is even a bill shows that people care for it.
But you understand that in courts we apply existing law, not proposed legislation, correct?
That is correct, yeah.
Thank you. You cannot tell this court, based on personal knowledge, that law enforcement violated the Fourth Amendment in this case, correct?
Objection, Your Honor, asked and answered. I believe it's been well established that Ms. Peters has no knowledge of the case today.
Any response to that?
They claim that she is their expert witness. However, when I'm asking her a question that she has no knowledge on, she cannot answer.
All right, I'll overrule the objection. Go ahead.
Thank you.
Yes, Your Honor.
You cannot tell this court, based on personal knowledge, that law enforcement violated the Fourth Amendment, correct?
Well, I'm not here to speak about this case specifically. I'm here to share that my personal knowledge of genealogy.
So, as a expert witness, and in your professional journalism, journalistic opinion, do you believe the Fourth Amendment was violated?
Yes, I believe so.
No further questions, Your Honor.
Thank you. Is there any redirect examination?
Yes, Your Honor. May I proceed?
Go ahead.
Why are cases like those of Richard Knapp or Michael Erskine relevant today?
Well, all of these cases use genealogy, and the Michael Usry and Richard Knapp cases show what could happen to a person if wrongfully accused. So I am just here to share my knowledge on that.
No further questions, Your Honor.
Is there any recross examination?
No, Your Honor.
Okay, you may step down. Thank you. All right, we'll give you about 2 minutes to collect your thoughts for closing arguments. Remember that the prosecution has 5 minutes, the defense has 5 minutes, and then the prosecution has 2 minutes if they wish to exercise rebuttal. Okay, so take 2 minutes.
Yes, Your Honor.
right, our counsel ready for the closing arguments?
The defense is ready, Your Honor.
State ready?
Yes, we are.
All right, you may proceed. Go ahead.
Your Honors, this evidentiary hearing is not about whether genetic genealogy is powerful, because it is, and is not about whether technology has advanced. It has. This hearing is about one question only. Did law enforcement act lawfully under the Fourth Amendment? Yes. And after hearing the evidence, I think we can all agree the state bears the burden to prove, by a preponderance of evidence, meaning more likely than not, that the genealogical research in this case was constitutional. We accepted that burden and we met it. Frankie Moyo testified clearly and credibly that he was informed about how his DNA would be used. He voluntarily chose to submit his DNA, and his failure to opt out is not the issue of law enforcement or Gene Heritage. It is the issue of the private citizen, as Gene Heritage made it completely clear on their website. He signed the terms and conditions without coercion, pressure, or threat, and his belief in the justice system influenced his decision to participate. Under Schneckloth v. Busterman, consent does not require perfect understanding or legal sophistication. The Constitution requires only that consent be voluntary under the totality of the circumstances. Frankie was not detained, questioned by police, and he was not threatened or misled. Even if he did not anticipate every possible future use of his DNA, Schneckloth makes it clear that voluntary consent does not disappear simply because someone later regrets their choices. Frankie's consent was voluntary. That alone is enough. The third-party doctrine in Smith versus Maryland, the Supreme Court held that the person has no reasonable expectation of privacy in information voluntarily shared with a third party, even if that information is later used by law enforcement. Frankie voluntarily shared his DNA with Gene Heritage. Gene Heritage lawfully maintained the information as part of its business records. Law enforcement accessed those records without intruding into anyone's home, body, or personal effects. Just as phone numbers dialed in Smith were business records of the phone company, the genealogical data here is the business records of Gene Heritage. Under Smith, this was not a Fourth Amendment search at all. And even if the court were to conclude that consent analysis is more complicated, Illinois versus Rodriguez protects law enforcement when officers reasonably rely on consent that appears valid at the time. Detective Ronan Saleh testified that he had investigated hundreds of cases. He followed proper procedures in acquiring and preserving evidence and the warrants. He relied on Gene Heritage's lawful framework, and every step of the investigation stayed within the boundaries of the law. There was nothing unreasonable about law enforcement relying on a voluntary user submission, a valid contract, and well-established consent structure. Rodriguez tells us the Fourth Amendment does not demand perfection, only reasonableness. And the detective's conduct here was unreasonably reasonable. Your Honors, the defense also asks you to rely heavily on its witnesses, but credibility and relevance matter. Val Barak's testimony was shaped by policy preferences and future career goals, not by any involvement in the investigation. He was not a part of the case. He did not submit DNA and offered opinions about what the law should be and not what the law is. Even Val conceded that individuals must take responsibility in reading terms and conditions, and that DNA evidence can lawfully be used when properly collected. The same is true of Haven Peters. Ms. Peters testified passionately about the potential risks of investigative genetic genealogy, but she acknowledged that she is a journalist and policy advocate, not an expert, not a forensic analyst, and not someone with personal knowledge in the investigation. The examples she discussed involved entirely different cases, different jurisdictions, and completely different DNA companies. She could not testify that law enforcement violated the Fourth Amendment here. She only believes that that the law should change in the future. The kind of testimony that belongs in a legislative hearing, not as proof of a constitutional violation in a case. Your Honors, we apply the law to the facts proven in this hearing. Schneckloth tells us that consent here was voluntary. Smith tells us that there was no reasonable expectation in privacy information voluntarily shared. Rodriguez tells us that law enforcement acted reasonably and in good faith. The Fourth Amendment was not violated. For these reasons, the state respectfully asks that you deny the motion to suppress and allow this case to proceed with the evidence lawfully obtained. Thank you, Your Honor.
Thank you, counsel. Counsel for defense.
Yes, Your Honor. May I proceed?
Yes.
May it please the court. Your Honors, DNA is essential. Therefore, it must be confidential. Today you heard the circumstances surrounding the state's attempt to stretch the limits of the Fourth Amendment to search a person's most private genetic information. The critical question in today's case is whether or not law enforcement's use of DNA through a third-party database constitutes a violation of the Fourth Amendment. Under the Fourth Amendment, people are protected against unlawful searches and seizures. The main issue here is that the state is violating this by manipulating the sharing and storage of Frankie Moyo's DNA. In the case of Katz v. United States, the court ruled that the Fourth Amendment protects people, not places, and established the two-part privacy test. 1, if the person expected privacy, and 2, the average person would agree that the situation deserves privacy protection. The state is violating this as an average person would agree that their DNA deserves privacy protection. Gene Heritage fails to properly warn its users of its law enforcement agreement, putting users' DNA at risk of use. Now today you heard from Val Barak, a sophomore at the Buckeye State University. As a student of Bailey Kim's Forensic Science course, Val, along with the other students, were asked to complete an extra credit assignment involving submitting their DNA to a database. He testified his suspicions and privacy concerns of Gene Heritage in their law enforcement agreement. Val described how Professor Kim failed to mention that Gene Heritage even had a connection with law enforcement. He described how only 5 companies were offered, some that cost up to $150. Gene Heritage, being the only free company, made college kids have to use it because it was affordable. And not to mention, Val strives to perfect every project with every detail. Without reading the lengthy terms and conditions, Val would have been unaware of where his DNA was really going to go. And now you also heard from Haven Peters, a journalist who investigated and reports on genealogy database websites. Her reporting reveals a concerning lack of transparency, showing how people's DNA is being used for more harm than good. Her work brings light to exactly what the Fourth Amendment seeks to prevent: unchecked government access to deeply personal information. Now you also heard from Mrs. Saleh, the investigator of C.J. Jansen's murder case. Mrs. Saleh testified on how she had access to Frankie Moyo's DNA through Gene Heritage. But not just her DNA, her whole entire family tree. Family members a part of this family tree that never even had the chance to voluntarily upload their DNA to the database. She never received explicit consent from these family members, and she never even told the family members that their information was in the hands of law enforcement. Now this situation mirrors Carpenter v. United States, where the court declared that just because information comes through a third-party database does not undermine an individual's reasonable expectation of privacy. Frankie Moyo's DNA, their most personal piece of data, unknowingly became a key piece of evidence in a criminal investigation. Your Honors, as we have learned today, we recognize the importance of DNA in our justice system. As it has helped catch criminals, its exploitation also imposes a threat to the right to privacy. The real question in today's case is whether or not law enforcement's use of Frankie Moyo's DNA through Gene Heritage constitutes a violation of the Fourth Amendment right of the federal Constitution. By the preponderance of the evidence, the state had the burden of proof to prove that the third-party doctrine applies, undermining an individual's reasonable expectation of privacy, and that Frankie Moyo gave consent. The defense has clearly shown that an individual who uploads their DNA to a private third-party database has a reasonable expectation of privacy. Furthermore, Frankie Moyo and his family did not give direct consent to the open use of their data and family tree to law enforcement. In the end, DNA is essential, therefore it must be confidential. So the defense respectfully asks you to uphold the right to privacy and not to allow law enforcement to have access to DNA through a third-party database without a warrant or without consent. Because DNA is not just data or evidence, it is part of who we are. Thank you.
Thank you. Is there any rebuttal?
Thank you, Your Honor. May it please the court. The defense claimed that we stretched the Fourth Amendment. However, law enforcement obtained a warrant at every point they felt it was necessary, and Gene Heritage allows for a privacy contract with a clear and concise opt-out contract about law enforcement and public info use. And we can all agree Frankie Moyo at the end of the day consented to his DNA being uploaded, and therefore it was public information after that. Thank you, Your Honor.
Thank you very much. We will have about a 2-minute time period you can discuss with your team members whether there are any post-trial objections, and then just let me know that, okay? You guys can be excused to begin your scoring. Yes.
Your Honor, the defense finds no post-trial objections.
All right, thank you.
Your Honor, the prosecution finds no post-trial objections.
All right, we will then retreat to score and then come back out and let you know, okay?
Wait. All right.
general comments at first, and then I think outstanding attorney award and Ms. Daniel outstanding witness award. First of all, thank you for engaging in this process. I know it takes a lot of work. We get the materials about a week in advance of you guys have been working on it since the fall, right? Since school started. We get them some 230 pages or so of this information about a week ago, so that's how we go through it. So you guys know much better than us. And I would like to commend both teams for being very familiar with the facts, being familiar with the rules, the evidence rules, and I'll clue you in on a little
All rise. Hear ye, hear ye. The U.S. District Court for the Middle District of Buckeye is open to pursuant to adjournment. All having business before this honorable court, give attention and ye shall be heard. You may be seated.
Thank you. All right, good afternoon. Are all counsel ready to proceed?
Yes, Your Honor.
All right, would you, let's start with the prosecution. Would you introduce your team?
Yes, Your Honor. Good afternoon. My name is Isabella Bastian. I'm here alongside my co-counsel, Grayson Reside.
Good afternoon, Your Honor.
As for our witnesses, we have Mitchell Morabin. Sorry, he's over there. He is playing Ronan Saleh. And then we also have Liza Goldberg, she will be playing Professor Billy Kim.
And for Kenston, the defense.
Yes, Your Honor. Good morning, good afternoon. My name is Will Turner. I'll be providing the opening statement on behalf of the defense. I'll be with my co-counsel, Reagan Carnes.
I'm Reagan Carnes, and I will be giving a closing statement on behalf of the defense.
Today, the defense will be calling two witnesses. First, we'll call Val Barak, played by Zoe Feber.
Good afternoon.
Then we'll be calling Archer Morales, played by Tommy Hart.
Good afternoon.
All right, counsel ready for opening statements?
Yes, Your Honor. Meanwhile, for those 25 years, the Jensen family waited. They waited for answers and for justice, as so many families do. That was at least until advances in technology allowed investigators to reopen the case and re-examine the evidence, leading to the arrest of Lori Remy. An outcome that was a result of a lawful investigative process grounded in individual choice. Frankie Moyo chose to upload their DNA to Gene Heritage, a genealogical database, in order to learn more about their identity and family history as an individual who was adopted. Once Gene Heritage legally possessed that information, they were permitted to share it with law enforcement because they had an established agreement with the police department that was clearly stated in the terms and conditions. And from there, every step of the investigation was lawful and proper. Today, the state will call two witnesses. First, Detective Ronan Saleh, a veteran and current head of the cold case division at the Harmony Police Department. He will explain how investigative genetic genealogy revived the Jensen case and how corroborating evidence, necessary warrants, and confirmatory DNA tests ultimately linked the defendant to the crime. Second, Professor Bailey Kim, a current instructor in forensic science and retired forensic lab technician, will testify to the unparalleled reliability and the scientific validity of genealogical matches in modern forensic investigation. And the state will show, by preponderance of the evidence, that the search that occurred is permissible under one of two exceptions: the third-party doctrine and the consent doctrine, such that no warrant was required before accessing the information from Gene Heritage. But first, we will demonstrate that Frankie Moyo consented to share their DNA with Gene Heritage, and that Gene Heritage's terms clearly state that it cooperates with law enforcement. Under the third-party doctrine, information voluntarily conveyed to a private company is not protected by the Fourth Amendment. Second, Frankie Moyo is entitled to share their DNA. It is theirs to do as they like, and they have the authority to give it to Gene Heritage, even if it implicated their relatives. Because DNA is not something we as individuals exercise exclusive authority over. We leave it behind everywhere we go, and we share with our relatives across time, geography, and circumstance. Much like co-tenants who share common authority over a space, consent from one individual with common authority, like a relative in this case, is sufficient. And when law enforcement has consent, a warrant is not required under the consent doctrine. Here, law enforcement had that consent, and their actions were lawful. You can't conceal what genes reveal, especially when more than 12,000 murders remain unsolved in the state of Buckeye. representing a family just like Caleb Jensen's, still waiting for answers. For these reasons, we respectfully ask the court to deny this motion, not victims and families seeking justice. Thank you, Your Honors.
Thank you. For the defense.
Yes, Your Honor. May it please the court. Without permission, this case has no vision. Nearly 26 years ago, Caleb C.J. Jansen was found murdered in his apartment. Investigators found DNA traces under his fingernails, but were unable to find a match. Harmony Police let the case go cold. Recently, investigators obtained, without a warrant, defendant Morgan Remy's genealogical data from Gene Heritage, a corporate ancestry site. Now, this site was never made with law enforcement in mind. Instead, it was created for families. People submit their DNA to find relatives, explore ancestry, or connect with their heritage, not to become part of a criminal investigation. Frankie Moyo submitted their DNA to secure extra credit points for an important class which would define their future. Yet, without a warrant, without judicial authorization, and without the knowledge of millions of innocent users, including Moyo, investigators were able to obtain genealogical data from Gene Heritage. Today, the defense stands before you requesting that the court grant its request to suppress. The prosecution will be unable to prove by the preponderance of evidence that a warrantless search was constitutional, either through the consent doctrine or the third-party doctrine. The United States Supreme Court held, in Georgia versus Randolph, that a warrantless search is unconstitutional if consent is either expressly refused or absent. In today's case, consent was most definitely absent, as Frankie Moyo never affirmatively consented to their DNA being used in an investigation, and certainly neither did Morgan Remy. Additionally, the third-party clause has no standing in today's case, as Carpenter versus United States held that when information held by a third party is legitimately private, a warrant is required. Because society recognizes an inherent value in the privacy of DNA information, a warrant was required. And because it was not used, all subsequent DNA evidence must be suppressed. To prove this, the defense will be calling two witnesses. First, you'll hear from Val Baruch, a student with a passion for forensic science, who was in the same course as Frankie Moyo. Her testimony will prove that Gene Heritage automatically shares DNA with law enforcement unless users are able to complete and find a hidden opt-out form. She'll also testify to the fact that Professor Bailey Kim never informed the class of the law enforcement user provision. Her testimony proves the system is confusing, misleading, and unreliable. But next, you'll hear from Archer Morales, the CEO of Gene Heritage. He'll confirm the fact that Gene Heritage automatically shares user information with law enforcement unless they can find and complete that hidden opt-out form. He'll also testify today to the unreliability of DNA evidence. Your Honors, this case is not about shielding the guilty. It's about defending the innocent. This case is precisely the type of government overreach the Fourth Amendment was written to protect. Because the search violated Morgan Remy's Fourth Amendment right, the genealogical evidence must be suppressed. The Fourth Amendment demands it. Our justice system depends on it. Without permission, this case has no vision. Thank you.
Thank you. State calls first witness.
Yes, Your Honor. State calls Ronan Sally to the stand. Good afternoon, Mr. Saleh.
Good
Can you please
afternoon.
state and spell your last name for the court?
Ronan Saleh, S-A-L-E-H.
Thank you. Can you please tell the court a little bit about what you do for a living?
I am the lead investigator for Harmony Police Department's Cold Case Division, and I have been since 2005.
What training, if any, have you received for this position?
I attended the Department of Justice's National Forensic Academy program, which is a program that lasts for 10 weeks and allows officers from different jurisdictions to learn about the newest cutting-edge forensic techniques.
Thank you. Can you please briefly describe your employment background?
I have been employed with the Harmony Police Department for 35 years.
And you can describe what the Cold Case Division does?
The Cold Case Division deals with unsolved crime cases that primarily have to do with murder. There are around 12,000 unsolved murders in the state of Buckeye, but our department has worked to do its part to bring that number down to 200.
It's very impressive. How long have you been working in this field specifically?
I started off as a patrol officer, however, I was promoted to detective in 1995. 5 years after that, I was assigned to the Cold Case Division, and I have been a lead investigator for 20 years now.
Can you please tell us more about what your job as the head of the Cold Case Division entails?
As the lead investigator for the Harmony Police Department's Cold Case Division, we have to deal with crime cases that don't have solid leads and evidence until technology is able to catch up. For example, the Caleb Jansen case went years without a solid lead, which is typical of the cold cases that I've worked on.
You mentioned the Caleb Jansen case. What's your connection to this case?
Well, I was assigned to the Caleb Jansen case in 2005, which was 5 years after Caleb Jansen had been murdered. I had just become a lead investigator at this time, making this case one of my very first cold murders.
What were your first steps when you received this case?
Well, I immediately started getting familiar with the case, especially since I knew that one of my former colleagues was one of the original detectives for the case.
And when you were reviewing the case, what investigative methods did you use?
I've helped implement a multidisciplinary model into our casework. First, we connect with forensic experts. Second, we use the newest technology available. And third, we use open source resources such as investigative genetic genealogy.
Are those methods what you use in this case?
Yes.
Thank you. Your Honor, I move under Rule 702 to qualify this witness as an expert in forensics, police investigations, and procedures in cold cases.
Objection, Your Honor. Pursuant to Rule 702, there are 2 prongs that this witness must meet. I'm concerned with the second prong, being that his testimony must be based on reliable, scientific, or specialized knowledge. Now, I believe that this witness's testimony is not reliable, considering they have a personal stake in this case, having had it for many years, and obviously believing that C.J. Jansen is the murderer, not yet convicted of that murder. So I would believe that they have the bias to convolute the reliability in testimony today.
All right, the objection is overruled. Go ahead.
No response.
No.
Thank you. Can you please explain what investigative genetic genealogy is?
Well, investigative genetic genealogy, or IgG for short, is one of those new cutting-edge forensic techniques that allows investigators to access additional DNA databases to check their DNA samples against.
And how does this process work?
Well, first we use CODIS, which is our police DNA database. However, using IgG, we can check through public DNA databases that have been compiled using Ancestry and genetic companies.
And how successful has IgG been in your investigations?
The effect in our department was immediate. Through the use of Gene Heritage and 2 part-time contract genealogists, we were able to identify several victims and make great advancements in those cases.
So you mentioned Gene Heritage. Can you tell us a little bit more about that?
Gene Heritage is a genetic company with a DNA database that makes it available to law enforcement agencies.
And were you able to use IgG's DNA databases in any of your cold cases?
Yes. In fact, I was able to use it in the Caleb Jansen case when I uploaded the DNA found underneath CJ's fingernails to Gene Heritage on June 12th, 2018.
Did you get a match?
Well, no, not initially. For years, we've only gotten a few low-level matches that were less than 1% shared DNA.
And what did you do with these matches?
Well, there was not much that we could do since it was only 1% shared DNA.
And so was IgG helpful at all as a resource?
Well, yes. In 2025, Gene Heritage notified me that someone had uploaded their DNA profile and that it was a 25% match with the DNA found underneath CJ's fingernails.
Are you familiar with who uploaded that DNA?
Yes, Frankie Moya.
And what did you do with this information next?
Well, our team found out that Frankie Moya was adopted in a closed adoption, which means which was unusual in our time working with Gene Heritage.
And with your kind of process for a closed adoption, what did you do?
Well, I went to the juvenile court to obtain a warrant and had the judge sign it. My team then began working on building a family tree and using standard investigative methods to rule out family members as potential suspects.
And what was the result of these methods?
The only person that we were not able to rule out from Moyo's family was Morgan Remy.
Your Honor, I'd like to admit Exhibit E. Let the record reflect that I'm showing opposing counsel a clean and normal copy of Exhibit E.
No objections, Your Honor.
Thank you. Judge, would you like a copy?
Yes, please.
All of them?
Just one. Thank you.
Detective, do you recognize this document?
Yes, this is the warrant authorizing the collection of Morgan Remy's DNA.
And during this investigation, did you follow all the proper protocols?
Yes, we obtained all the warrants necessary, which were 3 of them.
Can you explain what those 3 were?
Yes. One was to unseal the adoption records. The second was to search Remy's residence. And the third was to obtain his DNA.
And so why weren't you able to rule out Morgan Remy as a suspect?
Because in addition to a 25% shared DNA match, CJ had a personal connection to Remy. CJ had filed an internal grievance with his employer, alleging that gate delays were costing the company overtime pay, specifically citing Remy. This grievance was under active review at the time of the victim's death.
Is this reflected in the exhibit?
Yes.
And what actions did you take next based on these findings?
Well, this evidence gave us more than enough probable cause to obtain warrants to search Remy's residence and to obtain his DNA.
What were these findings after this investigation?
Well, we found CJ's gold signet ring displayed among other jewelry. On top of this, Remy's DNA was a 100% match with the DNA found underneath CJ's fingernails.
Thank you. Moving on, are you aware of any legislation related to your work?
Yes, I'm concerned about House Bill 12.
Can you tell us a little bit more about House Bill 12?
Yes, as I understand it, House Bill 12 seeks to protect individual rights to genetic privacy.
But aren't you concerned about violating individual privacy?
Yes, of course I am, like anyone would be. However, we would be otherwise ignoring publicly available information. If this resource isn't available, then more murderers will be able to get away with murder.
And in your expert opinion...
Objection, speculation.
Response?
Your Honor, the witness is simply giving his opinion as to what he believes in his personal and expert opinion what will happen as a result of House Bill 12.
All right, the objection's overruled. Go ahead.
And in your expert opinion, what impact will it have on cold cases if it passes?
Most murderers are not serial killers like the Golden State Killer. Most murderers only kill once. That means if any DNA is collected at the crime scene, it's not likely that it would match anyone in our police DNA database.
Thank you so much. No further questions.
Cross-examination.
Yes, Your Honor. Good afternoon.
Good afternoon.
So I first want to talk about how you first became aware of Gene Heritage. In 2018, you attended the Department of Justice's National Forensic Association, correct?
Academy program, yes.
Academy, yes. You attended a session about investigative genetic genealogy, or IGG, didn't you?
Yes, that was one of the methods that they taught us there.
At this conference, you learned about Gene Heritage, right?
This is correct.
Gene Heritage is one of those companies that makes their DNA available to law enforcement agencies, correct?
Yes, this is part of their policy.
So let's talk about the accuracy of the reports provided by Gene Heritage to the police.
Of course.
Isn't it true that with each report you got back from Gene Heritage, you noticed a disclaimer stating that they cannot guarantee the accuracy of samples that they did not personally collect, correct?
This is correct. However, I trust the labs that I use, such as Gene Heritage.
You notice that these disclaimers also said that they cannot confirm the accuracy of samples they did not process, correct?
This is correct, yes.
Let the record reflect, I'm showing opposing counsel a clean and unmarked copy of Exhibit B. Would Your Honors like copies of these as well?
Just one copy, please.
Now, if you would please direct your attention to numbered item 12, disclaimer of warranties. I'm going to read the second sentence Can you let me know if I read this correctly? The company disclaims all liability for errors, omissions, or inaccuracies, including but not limited to reliance on results for medical, employment, insurance, or legal determinations. Did I read that right?
Yes.
Now, Gene Heritage also states that they cannot guarantee the accuracy of their lab. Is that true?
This is true. However, it's impossible to have complete accuracy in something.
Now, you were not present when Frankie Moyo submitted their DNA. Is that true?
I was not present there, no.
You also weren't present when Gene Heritage processed Frankie Moyo's DNA, right?
That is correct, yes.
Now, let the record reflect I'm showing opposing counsel a 2-minute copy of Exhibit D. May I approach the witness?
Yes.
Would Your Honor like a copy of this exhibit as well?
Just one.
Now, I'd like you to turn your attention to the back page, to the final disclaimer. I'm going to now read the third sentence of this disclaimer. You let me know if I read it right. The results contained in this report are provided as is for informational and educational purposes only, and are not intended to be relied upon for medical diagnosis, treatment, employment, insurance, legal determinations, or other decisions of personal or financial consequence. Is that correct?
Yes, you read that correctly.
Now, let's talk about any potential bias that you have in this case against my client, Morgan Remy. We are here today in a motion to suppress hearing to determine what evidence will be presented at the trial, correct?
That is correct.
Now, you personally believe that Morgan killed CJ, don't you?
I believe that, but I do not let my bias get in the way of my statement.
I mean, didn't you tell CJ's family that you had identified the murder?
I did, yes, because it was important to let them have closure.
Morgan Remy hasn't been convicted yet, has he?
Not yet.
Morgan Remy hasn't been to trial yet, has he?
He has not yet been to trial.
Now, Morgan and CJ, they worked together, didn't they?
They worked at the same company, yes.
Now, you have made the assumption that the DNA was placed under CJ's fingernails during the murder, correct?
That is correct.
And you actually can't be sure when the DNA got under CJ's fingernails, can you?
Well, it was found at the direct crime scene, which happened shortly after.
But they did work together, didn't they?
They did, yes.
While executing your search warrant for Remy's residence, your squad found CJ's gold signet ring displayed with the other jewelry that Remy wore regularly, right?
That is correct, yes.
Now, the second you saw the ring, you believed that you knew Remy killed CJ, correct?
Objection, speculation.
Response?
Your Honor, I'm asking for the opinion that this witness had at the time in which she observed Remy's apartment.
All right, objection's overruled, go ahead.
So, yes or no, did you know or believe that you knew that Remy killed CJ?
Well, I did believe it, yes. I mean, it's hard to see how he couldn't have been since the ring was right there.
But you don't know for sure how Remy obtained that ring, do you?
Well, I'm not completely sure, but
And I just want to make clear to the court, Remy and CJ knew each other before the murder took place, correct?
they knew each other. However, they did not have a positive relationship due to the complaints that they filed against one another.
So that's a yes?
Well, they knew each other, but not
So
positively.
let's talk about Frankie Moyo's adoption. Now, Frankie Moyo was adopted, wasn't he?
Yes.
You understand that in some adoptions, the child can learn who their birth parents are, correct?
Yes, but he was adopted in a closed adoption.
Exactly. So closed adoptions mean that genealogical relationships are meant to be private, right?
Yes.
Indeed, you had to obtain a warrant to unseal this adoption record to learn who Frankie was related to, didn't you?
I had to do that, yes.
And the juvenile court had to give you a warrant to unseal this record, right?
That is correct.
Only after you unsealed this record, through a warrant, were you able to identify Frankie's relatives. Is that true?
That is correct.
So just to be clear, you needed permission to obtain these records.
And I got that permission.
Thank you, Your Honor. No further questions.
Any redirect examination?
Yes, Your Honor. Just going back to some of the questions that opposing counsel kind of asked you, what corroborating evidence did you find after the case was reopened?
I was able to find CJ's gold signet ring. I was able to find the DNA match between Frankie and Morgan Remy.
And can you give me the timeline for when you found this corroborating evidence?
Well, first, Gene Heritage notified me that somebody had uploaded their DNA evidence, and that would be Frankie Moyo. I then obtained a warrant to unseal the adoption records, and then I obtained warrants to search Remy's residence and to obtain his DNA.
But was the corroborating evidence
Yes.
No further questions, Your Honor.
Any recross-examination?
Yes, just briefly, Your Honor. So, regarding this ring that we just talked about in redirect, you don't know for certain how this ring was acquired, do you?
I don't know for certain, no.
Alright. I also want to be clear, Morgan and CJ knew each other before the murder took place, didn't they?
They knew each other, but they did not have a positive relationship.
They worked together, correct?
They filed complaints to one another.
So, just to be clear, is that a yes?
Well, they did work together.
Thank you, Your Honor. No further questions.
All right, you may step down, Judge Lee. Next witness.
You would like to call Bailey Kim to the stand? Good afternoon. Please state your name and spell your last name for the court.
Good afternoon. My name is Bailey Kim, K-I-M.
So, Professor Kim, what is your current occupation?
I work as a professor of forensic science at the Buckeye State Community College.
And what courses do you teach there?
I teach forensic science and its application in the legal field. And my class is dual enrollment, so I'm able to teach both high school and college students. My coursework covers various topics like lab processing, short tandem repeat analysis, and genetic relationships with DNA.
And what made you want to teach students?
I want to teach students because they're our future.
And what kinds of extra credit assignments, if any, did you offer?
I offered one extra credit assignment. It was to submit DNA to a genealogy database.
And was that assignment mandatory?
No, this assignment was completely optional. A lot of my students don't agree with my views, and I invite them to fight back and let me know that they don't want to do something. It was completely optional, and I did not force it upon anybody.
Moving on, could you describe your background related to forensic science?
Yeah, for a lot of my career, I worked as a forensic lab technician with the local police department. Although I don't work there anymore, I'm still very involved with the law enforcement field, and I attend police conferences around the country to stay up to date with advancing technologies. As technology advances, so is our legal system, so it's very important to me that I understand everything that's going on.
And how long did you work as a forensic lab technician and with law enforcement?
Ooh, I worked there for a long time. My colleagues like to call me the grandmother of forensics.
And why is that?
Well, because I worked there for so long and I'm so well known in the field.
And to what extent do you use DNA testing as a part of your investigation?
When I worked as a forensic lab technician, I used it all of the time. Lab processing and DNA analysis was part of my job.
And can you expand on your professional background a little bit more as it relates to DNA?
Yeah, when I worked as a forensic lab technician, I handled a lot of different DNA samples and working on short tandem repeat analysis, as I mentioned before.
Your Honor, at this time, I would like to enter this witness as an expert in forensic DNA analysis under Rule 702.
Objection, Your Honor. This witness does not have enough expertise, experience, or education in specifically investigative genetic genealogy, which is the only relevant part of forensics that we are here discussing today.
Yeah, so at this time, they are currently an instructor at a community college on forensic science, which touches in-depthly on those topics. As well as that, they have extensive experience in the forensic lab field as a forensic lab technician for many years. That's why they're called the grandmother of forensics. And under Rule 702, they meet all the qualifications.
All right, the objection is overruled. Go ahead.
Thank you, Your Honor. Going back to the extra credit assignment, what was the purpose of offering it?
Well, throughout the whole semester, we've been looking into how DNA can show genetic relationships and how law enforcement can use this to solve cold cases. Because of this, I wanted my students to have a real-life example of this so they could see their own family tree and how their genetics can lead them to other people.
And in what ways is DNA typically analyzed in forensic laboratories?
Usually in forensic labs, it's handled with short tandem repeat analyses. This method is a way to compare two DNAs and see if they have the same repeat tandem methods.
Can you expand on this a little bit more when it comes to like biological relatives and family members?
Yeah, there's also autosomal DNA, which can help show relationships between two individuals, and you can trace back DNA based on the amount of shared DNA two people have.
And based on your experience, what is your professional opinion on how reliable DNA is as an investigative tool?
I think that DNA is as reliable as it gets. If it's handled and taken with the correct standard laboratory protocols, then it can be key to solving a case and identifying or ruling out a suspect with a high level of certainty.
And what is the importance of genealogical-based DNA analysis as evidence in things like cold cases?
Well, in cold cases, in the past, it was often hard to figure stuff out because we didn't have the advanced technology like genealogy databases as now. When I go to my police conferences and I learn about these technology tools like genealogy, I want cold cases to use them as they can take the old evidence they have, bring it back, and cross-check it with the new DNA found.
Thank you, Your Honors. No further questions.
Thank you. Cross-examination.
Yes, Your Honor.
Good afternoon. Please answer the following questions in a yes or no form.
Good afternoon. I will try my best to use yes or no, but if I need to expand, then I will answer with how I please.
First, let's talk a little bit about you. You are currently a forensic science professor at the Buckeye State Community College, correct?
Yes, I am.
And you used to be a forensic lab technician, correct?
Correct.
But you have now retired from that work, right?
Yes.
And now you teach about lab work, right?
Correct.
In fact, both Frankie Moyle and Val Barak were some of your students.
Yes, those were a few of my students.
And you took both of them on as mentees, right?
Yes.
Now let's talk a bit about the extra credit you assigned. Now, investigative genetic genealogy is a very new system, isn't it?
Yes, that is correct.
But regardless, you assigned IGG as an extra credit assignment for your class, right?
It was an extra credit assignment if my students wanted to learn more about this specific topic.
So students could get a boost to their grade if they submitted their DNA to a company.
The grade boost was just a minor portion of it. The main point of the assignment was to educate my students and give them a real-life example of this.
But they would get a boost to their grade, correct?
Correct.
And you also acknowledge the privacy concerns of IGG, don't you?
Yes, I do.
And some students in your class didn't even like this assignment. Isn't that true?
Yeah, my class is a very open space, and if my students don't like an assignment I assign or something I teach them, then I'm very open for them to come to me and talk to me that they don't agree with something.
Right. You encourage others' opinions on this matter, don't you?
Yeah.
And you had no idea that a student could potentially be traumatized by the extra credit you assigned.
No, I didn't expect something like that to happen.
And you believe that many students actually underestimated the power of this assignment, don't you?
I think they could.
Now let's talk a bit about the privacy concerns of websites like Gene Heritage. You're familiar with House Bill 12, aren't you?
Yes, I am.
Your Honors, I am now showing opposing counsel a clean and unmarked copy of Exhibit A. May I approach the witness?
Yes.
And here's a copy for Your Honors.
Thank you.
Thank you.
Now, this is a copy of the sponsor testimony for House Bill 12, correct?
Yes.
And under the section titled The Problem with Current Practices, the second sentence, it says, while convenient and popular, these services frequently require individuals to hand over their most sensitive personal data to private companies. Did I read that correctly?
Yes.
And then under the section titled What House Bill 12 Does, the third sentence, it states, it requires companies operating in our state to implement explicit protections ensuring transparency and accountability in how genetic data is collected, stored, and shared. Did I read that right?
Yes.
Perfect. And this is a state House bill, right?
Correct.
Now let's talk a bit more about gene technologies. Even without access to websites like Gene Heritage, law enforcement can narrow down a suspect pool via their own technology, right?
Yes, that is correct. In my career, before it was very widespread as the grandmother of forensics, we found other ways to find and solve cases.
Right, and you yourself do have concerns about the work of investigative genetic genealogy, don't you?
Yes, I know that it can have its flaws.
In other words, hiccups are bound to happen, right?
Yes.
And IGG is also a very difficult process, isn't it?
Yes, it can be.
And that's why law enforcement officials only use it as a last resort, right?
I think that because it's so new, it's a bit difficult to use, but DNA evidence is always a very reliable form of evidence.
Thank you. No further questions.
Thank you. Redirect?
Yes, Your Honor. Hi, so what is your policy for assigning extra credit assignments?
When I assign an extra credit assignment, I make sure to put emphasis on the extra. It is completely optional and not something that my students need to do.
And did you ever tell your students that it was necessary in any way?
No, not at all. In fact, most of my students are doing pretty good in my classes, as I have high school students that are the brightest of the bunch, so they didn't need to do the assignment if they didn't feel comfortable with it.
Thank you. No further questions.
Any recross examination?
Just briefly, Your Honor. So, just to reemphasize, in an extra credit assignment, you would still get a boost to your grade if you did the assignment, correct?
Yes, there is a minor boost that goes along with this assignment.
So, by doing this assignment, your students could raise their grade for doing this assignment, right?
That is true, but I made sure when I assigned the assignment to let them know that they did not need to do it if they weren't comfortable, because I know that it is sensitive information.
Thank you, Your Honor. No further
All right,
questions.
thank you. You can step down.
Thank you, Your Honor.
All right, defense, you want to call your first witness?
Yes, Your Honor. We would like to call Val Barak to the stand. Good afternoon. Please state your name for the record.
My name is Val Barak.
And how old are you?
I'm 20 years old.
And what do you do, Miss Barak?
I'm a sophomore at the Buckeye State University, where I'm currently a pre-law student.
And do you have any plans for after your undergraduate studies?
Yes.
Objection leading.
Response?
Your Honor, this is not implying a specific answer, but if you would like me to rephrase the question.
All right, the objection's overruled. Go ahead.
Would you like me to restate the question?
Yes, please.
Do you have any plans for after your undergraduate studies?
I do. After receiving my undergraduate degree, I plan to go to law school. My dream school is the Queen City University College of Law. I've already started studying for the LSAT because it's one of the best law schools in Buckeye. After law school, I want to become a public defender.
And why do you want to become a public defender?
Because I've always understood the importance of making sure that accused people get the zealous defense that they deserve. It's also important for defense attorneys to make sure that the evidence used in their client's trial is collected and handled properly.
And what experiences fostered those values?
Well, just last year, actually, I had a close brush with the whole idea of improper forensic investigation. At the time, I was in Professor Bailey Kim's forensic science class at the Buckeye State Community College. I didn't agree with everything that Professor Kim said and did in the class. For example, I didn't like the extra credit assignment that Professor Kim gave out near the end of the year.
And what was that assignment about?
Basically, we could get extra credit by submitting our DNA to one of a selection of genetics companies.
What did you end up deciding to do?
Well, Professor Kim gave us about 5 different companies that we could submit our DNA to. I was surprised and a little suspicious of Gene Heritage, which was the only free company listed, so I did my research. I thoroughly read, printed, and highlighted all the notable parts of their terms and conditions and their law enforcement use provisions.
And how did you feel about this assignment?
Well, if you didn't already notice, I'm someone who pays close attention to detail. I always cross my T's and dot my I's. I was skeptical. It didn't seem like much of a learning opportunity. All you had to do was swab your cheek, submit your DNA, and write a short reflection. Still, I was definitely interested in completing the assignment, especially because of Professor Kim's reputation for harsh grading.
And what did you learn about Gene Heritage after doing your research?
I learned that Gene Heritage operates off funding from public safety grants and private philanthropy. They do share their database with law enforcement, and they do offer an opt-out option by filling out an additional opt-out form, and then they won't share your DNA.
Was your class ever informed of this relationship with law enforcement?
No, Professor
Objection,
Kim never.
speculation.
Response?
Your Honor, this witness was in the class. She would know if she was ever informed of this relationship.
All right, the objection's overruled. Go ahead.
Would you like me to restate the question?
Yes, please.
Was your class ever informed of Gene Heritage's relationship with law enforcement?
We weren't. Professor Kim never informed any of us in class that Gene Heritage cooperated with law enforcement.
So what did you decide to do after learning that?
I decided not to complete the extra credit assignment. It just wasn't worth the privacy concerns for me.
Did you ever discuss these concerns with your classmates?
I did. During a short class discussion, I brought up my privacy concerns. Some of the students in the class were shocked to find out that Gene Heritage cooperated so much with law enforcement. And some even said that they had never read the terms and conditions and thought that an opt-out requirement was a little shady.
And how did others react to the information you shared?
Some of my classmates seemed upset with Professor Kim because they hadn't told us about the privacy concerns. Even Frankie Moyo, one of the lower academic students in the class, said that maybe they should read those things more carefully from now on.
Did refusing to not participate in this assignment impact your grade?
It did. Almost everyone in the class completed the extra credit assignments, and I didn't, and Professor Kim grades on a curve, so my grade ended up lower than it would have been otherwise if it was just a straight average.
And have you continued studying issues related to DNA and privacy since then?
I have. I've done a lot of DNA-related research during my time as a pre-law student.
Do you have any other legal experience?
Yes, the Buckeye State Innocence Project actually offered me one of their exclusive undergraduate fellowship spots. The Innocence Project at BSU is a large organization based in the Boris College of Law that accepts some undergraduate students to do non-specialized work, like meeting with inmates and doing legal research. I even wrote my freshman seminar paper on DNA, false convictions, and the dangers of police mishandling DNA.
And what did you learn about the risks of mishandled DNA?
I learned that DNA can implicate innocent people if mishandled. In the Golden State Killer case, the police's first DNA match led them to a 73-year-old nursing home resident with failing health in Oregon.
Have you done any further work related to genetic privacy?
I have, actually. My freshman seminar professor, Masaki Honda, invited me to join her junior-level public policy course, even though I'm only a sophomore. In Professor Honda's class, each student chooses a state-level action or bill to research and follow as it moves through the government. I chose House Bill 12, which, if passed, would create a statutory right to privacy for any genetic information.
Your Honors, I'm now showing opposing counsel clean and unmarked copies of Exhibit A. May I approach the witness?
Yes.
And I believe Your Honors already have a copy of this exhibit?
Yes, we do.
Thank you.
What is this exhibit?
Excuse me. This is the sponsor testimony for House Bill 12.
And could you please summarize the section titled The Problem with Current Practices?
Yes. This says that a lot of Buckeyes today use those DNA testing kits and ancestry sites for insights into their genetic history. Even though they're popular, those services often require individuals to hand over sensitive data, and then that data is often shared with law enforcement or pharmaceutical companies with little transparency.
Thank you, Ms. Brock. Could you please now summarize this section titled What House Bill 12 Does?
Objection, relevance.
Response?
Your Honor, for starters, this has already been pre-admitted as an exhibit for this court, and second, this will become relevant in proving the third-party doctrine and that society has a reasonable expectation of privacy around genetic information.
All right, objection's overruled. Go ahead.
Would you like me to ask the question?
Yes, please.
Could you summarize the section titled What House Bill 12 Does?
Of course. It says that House Bill 12 will respond to this issue by making sure that Buckeyes have that right to privacy in their genetic information and it will require companies to implement protections and ensure that transparency that we're really lacking right now.
And why is such a law important?
Because the question of whether sensitive genetic information should be used by law enforcement shouldn't be up to some randomly assigned judge. In Representative Durbin's testimony in support of House Bill 12, he explains how this genetic information can be misused by companies like Gene Heritage, and that misuse can often lead to bad consequences, like false convictions.
Your Honors, I'm now showing opposing counsel clean and unmarked copies of Exhibit C. Would Your Honors like a copy?
Yes, please. Thank you.
And my approach to witness?
Yes.
Thank you.
Could you please turn to Section 9 titled Amendments and read it for the court?
Yes. Says Gene Heritage reserves the right to amend these law enforcement use policies at any time. Material changes will be communicated to users, and continued use of the services constitutes acceptance of such changes.
What does this policy mean?
This means that continued use of the Gene Heritage service will imply agreement to any updated terms.
And what does that mean for users, in your opinion?
Well, Gene Heritage does obviously operate with law enforcement, and they do share any potential matches with their clients, but there's a room for many loopholes in ways that the DNA can still be mishandled.
How do you personally view Gene Heritage's relationship with law enforcement?
I believe that the Fourth Amendment should protect individuals from having their DNA used all willy-nilly by law enforcement.
Thank you. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon.
Good afternoon.
So, Ms. Barak, you consider yourself a highly motivated pre-law student, correct?
Yes, I do.
And you wanted to become a public defender for a long time, right?
I have. I really believe it's important to make sure that things are handled properly.
And part of that involves being critical of law enforcement practices, correct?
Of course.
And you feel very strongly about genetic privacy, yes?
Yes, through all the research I've done, I've understood why it's such a big concern today, and I really think that things such as House Bill 12 should be implemented in order to address those issues.
Right, like you've written papers, taken classes, and publicly advocated on these issues, yes?
Yes.
Excuse me. And you criticize law enforcement's use of DNA multiple times, correct?
I criticize their use of DNA, especially when consent isn't fully given, such as with Gene Heritage.
So you're not neutral on issues involving DNA collection, yes?
Not when the DNA is collected with little consent. No, definitely not.
Moving on, you have a close relationship with Professor Kim, correct?
I do. Professor Kim has become somewhat of a mentor to me. I was really interested in getting to know her, especially because of her practical experience in the legal field.
They even wrote you a recommendation letter, yes?
Yes, she did.
But you disagreed with them about the extra credit assignment, correct?
Yes, it seemed a bit suspicious to me, Gene Heritage's cooperation with law enforcement and with Professor Kim, that she hadn't told any of us in class about the privacy concerns.
And you were disappointed with the final grade you received, yes?
Just a little. I mean, everyone else in the class just completed the extra credit assignment except for me, so of course my grade was a bit lower, but what else could I expect?
So you came away from that class with some frustration, yes?
A little, but I was definitely still glad that I got to know Professor Kim and, of course, got the experience that I got from that class.
Moving on, you have concerns about DNA being mishandled and implicating innocent people, right?
Yes, of course. I think it's a big problem in cases such as this or the Golden State Killer case, that DNA can cause a bit of a false alarm in many cases.
You also think that DNA misuse is dangerous, yes?
Oh, of course.
So overall, your mindset is that DNA evidence is risky and easily abused, correct?
Correct. Though I do think that if people follow the proper protocols and get full consent from anyone involved, then it's, of course, important to be used in court cases.
And you've advocated for the bill HB 12, the bill limiting law enforcement's use of DNA, correct?
Yes. Well, it wouldn't eliminate their use of DNA, but it would create stronger protections.
Yeah. But this bill has not been passed, correct?
Not yet, no.
So its various regulations on DNA have not been enacted into law, yes?
That's right, correct. It's still currently moving through the government.
Right, and you wrote a letter supporting this bill, right?
Well, Professor Durman wrote a sponsor testimony, which is what I read earlier today.
And you encourage your classmates to do the same, correct?
Yes.
And you believe genetic information should be protected from government use, correct?
I believe that genetic information is extremely sensitive and should be treated as such. Of course, as I said earlier, if it's treated with that respect and given full consent, then of course it's important to be used in court cases.
Right, and the outcome of today's case could potentially be used as support for the legislative outcomes you seek, correct?
I suppose it could, yes, but House Bill 12 is looking more to these general issues that we see today, and it's common in a lot of court cases, definitely not unique to this one.
Right, but despite your strong opinions, you are not a forensic scientist, correct?
I'm not, though I love forensic science.
And you've never worked in a crime lab, yes?
Well, I've had experience with forensic science through my work with the Buckeye State Innocence Project, so I've done a lot of legal research, but I've not had experience specifically in a lab, no.
Right, so you've never processed like DNA in a real investigation, yes?
Objection, Your Honor, relevance.
Response?
This witness has talked about their credibility when it comes to the field of forensics. I'm simply limiting it and talking about where, their credibility might have some limitations in terms of the practical applications of forensics, not just the research.
All right, the objection's overruled. Go ahead.
So your views on DNA procedures only come from readings, correct?
I've done a lot of research into the subject, and of course the courses that I've taken at the Buckeye State College, such as with Professor Kim, have given me a lot of insight into these issues.
Right, you are a very diligent and detail-focused student, correct?
Yes.
In fact, you read the entirety of Gene Heritage's terms and conditions, yes?
Yes, I did a lot of research into gene heritage.
As well as the law enforcement use policy, correct?
That's right.
And you read these terms thoroughly, yes?
Yes, I even highlighted.
Let the record reflect, at this time, I'm showing opposing counsel a clear and unmarked copy of Exhibit B. I believe your owners already have a copy,
Yes.
yes?
No objections, Your Honor.
May I approach the witness?
Yes.
Do you recognize this document?
Yes. This is the Gene Heritage Terms and Conditions.
Oh, I'm sorry. And you read this document entirely before, correct?
Yes, I did. I read it very carefully.
Can you read number item 4 for me, please?
Yes, just give me one moment. Number 4 says...
Just the title.
Oh, okay. Data sharing and law enforcement access.
And the rest of the paragraph talks about the specificities of it, correct?
Yes, it does.
So law enforcement cooperation was disclosed from the beginning, correct?
It was, though I was only able to find this after looking thoroughly into the terms and conditions. As I said, I highlighted and printed.
Right, but you were unable to move onto the next page until you scrolled entirely through the terms and conditions and pressed accept, correct?
That's right, though many students in my class even said they never read the terms and conditions.
Right, but you still have to scroll through the entirety of it in order to move on, yes?
That's right.
Let the record reflect, at this time, I'm showing opposing counsel a clean and unmarked document of Exhibit C.
No objections, Your Honor.
Thank you.
Do you recognize this document?
Yes, this is that law enforcement use policy.
Yes. And this document goes into detail about Gene Heritage's cooperation with law enforcement, correct?
It does.
And again, you had to scroll through the entirety of the terms to accept before moving on, correct?
Yes, though again, like I said, I was only able to really understand their cooperation with law enforcement after doing a lot of research, and a lot of my classmates weren't as diligent as I.
Right, but if you're pressing accept, then it's expected that you read it, no?
I suppose that's what the website would like, yes, though it seems to me that most students wouldn't have done that.
Right, but you had the option to opt out as it stated, correct?
By filling out an additional opt-out form, yes.
Right, but in the end, you decided not to participate in the assignment entirely, yes?
That's right, and my grade did suffer because of it, but I'm glad that I did my research and was able to understand the privacy concerns that my classmates may have missed.
So you didn't submit your DNA to Gene Heritage, correct?
That's right.
But if you did, it would have been your choice whether or not law enforcement had access to it, correct?
Yes, though I will say I seemed a little bit more informed than many of my other classmates who did decide to participate in the extra credit assignment.
But it still would have been your choice?
It was my choice, yes.
Okay, perfect. No further questions, Your Honor.
Thank you. Counsel?
Yes, Your Honor. Why did you end up deciding not to participate in this extra credit assignment?
Well, after doing a lot of research, I understood the full extent of Gene Heritage's cooperation with law enforcement, and I decided not to participate because of my privacy concerns.
And what were some other people's opinions on this?
Many of the students in my class were shocked to find out about the law enforcement cooperation and were upset with Professor Kim due to their lack of transparency about it.
And what is your personal opinion on Gene Heritage's relationship with law enforcement?
I really believe that the Fourth Amendment should protect the individuals from law enforcement using their DNA as they are now.
Thank you, Your Honor. No further questions.
Any recross examination?
Yes, Your Honor. The extra credit assignment you were given was optional, correct?
It was, yes, though with Professor Kim grading on a scale and their reputation for harsh grading, I certainly would have recommended it.
Right, and since the class is so difficult, you would expect that your classmates are able to read, correct?
I would hope so, yes, though it seems that many of them still did not.
Right, but the terms and conditions, you would have to scroll through the entirety of before moving on, correct?
You have to scroll through, yes, but you don't necessarily have to read it. There's no way of the website knowing whether you did or not.
Right, but you still can't move on or through all of them entirely, correct?
Until you scroll through, yes.
Perfect. No further questions.
Thank you. You can step down. Next witness?
Yes, Your Honor. The defense calls Archer Morales to the stand.
Good afternoon, Your Honors.
Good afternoon, Mr. Morales. I want to begin by talking a little bit about you. Please state your name and occupation for the record.
My name is Archer Morales, and I am the CEO of Gene Heritage.
Please tell the court a little bit about your childhood.
Well, I was born in 1980, and I was immediately given up for adoption by my birth mother. I was raised by a loving family in Chicago. I wouldn't trade my upbringing for a thing, but I never felt like I quite fit in.
Could you expand on that?
For instance, my entire family could curl their tongues, but I couldn't. See? I asked my elementary school teachers why I couldn't curl my tongue, and they told me that it was something passed down through genes from my mother and father. The answer never made sense to me because my mother and father would have passed the gene down to me, right?
How did you learn that you hadn't inherited this gene?
Well, in 1998, the year I turned 18, my mom and dad sat me down. They told me that now that I was an adult, it was time to tell me the truth, that I was adopted.
Let's move on to your knowledge, training, and experience. What did you do after high school?
After high school, I attended the Buckeye State University and majored in finance. I had always been good at numbers, another characteristic I did not share with my birth family. I graduated in 2002 and got a job as an investment trader in Chicago.
What got you interested in DNA genealogy?
Around 2003, it started becoming more prevalent. I had only learned about my adoption a few years earlier, but was curious whether I could locate my parents or even other half-siblings through genealogical testing.
Did you act on that curiosity?
I was hesitant to try it at first, but finally, in 2007, I submitted my DNA profile to one of the early initiators. Boy, was it expensive.
Tell the court, what inspired you to create your company?
On November 3rd, 2016, I put my notice at my investment trading job. I instead wanted to reunite families through the use of genealogical testing.
Please, tell us more about your business.
I'm proud of my company and what I have built. I intentionally made the primary service of hereditary matching free, considering my personal life experiences. However, only the primary service is free. We also offer enhanced services such as health risk analysis and DNA storage for an additional cost.
Believe it or not, the money we make from our enhanced services makes up about 90% of our budget.
What is another source of income for your business?
We also receive a $15,000 public safety grant from the state of Buckeye.
How did Gene Heritage come to have a relationship with law enforcement?
Well, one day, Gene Heritage received a subpoena for any and all DNA in our system that matched a sample from a murder scene. I complied with the subpoena, and thankfully, law enforcement was able to apprehend the murderer. Then I thought, why don't I do this on a voluntary basis instead of waiting for the subpoena?
So, does Gene Heritage have an opt-in or opt-out provision?
Opt out. We make all profiles that we collect available to law enforcement for potential matches, unless the depositor opts out of their profile being included.
Let's move on to your knowledge surrounding your company. How does Gene Heritage work?
We focus on genetic genealogy. Without boring you with all the technical facts, genetic genealogy is nothing more than a matching system. We have a proprietary algorithm or formula that looks for STRs, also known as short tandem repeats, in the autosomal DNA and matches it with STRs in other DNA profiles to locate potential relatives.
What are STRs?
STRs are just patterns in the DNA. When we find a match, we submit a report to the requesters along with the certainty of our matches.
What is included in these reports?
Companies' reports are detailed with scientific information, including the degree of connection, along with an explanation of why we believe the data to be accurate.
Your Honor, I hereby move to request that you certify Archer Morale as an expert witness in the field of gene heritage procedures and practices.
Objection, Your Honor. This witness, under Rule 702, must have demonstrated previous training or specialized experience that has not done so far.
Your Honor, under Rule 702, my opposing counsel is referencing prong 1 that this witness must meet. They must meet either substantial experience, training, or education. We've proven that they've reached multiple of these things. Most prominently, their experience in running a company, in running Gene Heritage, which they're going to be testifying as an expert on behalf of. They have been running this business as the CEO from the beginning of the company to how it stands today. Additionally, their education is in a field surrounding business, which Gene Heritage is a business, which they will be testifying today. So they both do have the experience and education when they only need one or the other.
May I respond, Your Honor?
Yes.
In terms of prong 2 of the Rule 702, the witness must also have demonstrated specialized, reliable or technical scientific information. The witness is not given any sort of that.
All right, I will overrule the objection. Go ahead.
Thank you, Your Honor. All right, so I want to talk about the DNA at question in today's case. Let the record reflect, I'm showing opposing counsel a clean and unmarked copy of Exhibit D. I believe Your Honors already have a copy.
Yes.
What is this document?
Well, this is the Gene Heritage Kinship Match Report for Frankie Moya.
Now, if you look to the kinship match report section, what does the disclaimer underneath it say?
The disclaimer basically says that this is a law enforcement user match and that we as Gene Heritage cannot guarantee the accuracy of law enforcement user matches as they process their own samples, and we cannot guarantee the accuracy of third-party samples.
What is the process to complete an opt-out form for this information?
If the depositor checks the box, once the intake form is submitted, they will be redirected to a different part of our website where they will complete a separate form to opt out, meaning they will have to go through another process to submit their DNA.
Let's move on to your company's terms and conditions. I'm now showing opposing counsel a clean and unmarked copy of Exhibit C.
No objection, Your Honor.
I believe Your Honors also has a copy
Yes.
of this. Now, what is this document?
This is the Gene Heritage Law Enforcement Use Policy.
Would you tell us what Section 4 states?
Section 4 basically says that contamination or laboratory error can indicate things like false positives and false negatives.
Could this change the opt-out process in the future?
There's a new law pending in Buckeye's General Assembly that would guarantee an individual's privacy interest in genetic material. This would require Gene Heritage to change our entire procedure and have an opt-in provision versus our opt-out provision.
What is Gene Heritage's relationship with law enforcement in the status quo?
Well, law enforcement can submit profiles to our company and we'll store them in our system. Unlike our direct-to-consumer kits where we do the analysis of the samples and upload the genetic profiles ourselves, law enforcement users will upload the genetic profiles themselves and process their own samples.
What happens when they get a match?
When matches occur, law enforcement users are given the same amount of data that any other user would be given, except for any opt-outs. No warrant or request is needed to trigger this process.
Let's finish by talking about the efficacy and intended use of Gene Heritage's tests. If you would turn your attention back to Exhibit D, please tell the court what the final disclaimer on the back page means.
Apologies. Cannot seem to find Exhibit D. Did you mean Exhibit C?
I'm now showing opposing counsel a clean and unmarked copy of Exhibit D. I believe Your Honor has a copy of this?
Yes.
Now, if you would look to the final page, please tell the court what this final disclaimer means.
Essentially, this final disclaimer means that no genetic testing process can be guaranteed accurate, and that the results from genetic testing processes are to be used for informational and educational purposes only, not for a myriad of other things such as legal determinations.
Thank you, Your Honor. No further questions.
Thank you. Prosecutor?
Yes, Your Honor. Good afternoon, Mr. Morales.
Good afternoon.
Let's first start talking about your kind of interest in genetic genealogy. You first became interested in genetic genealogy because it helped find your family, correct?
Yes, I was very grateful.
Yeah. However, when you located your family, you found that your mother had been a victim of a violent crime, correct?
That's true.
But you also learned that the detectives who had investigated your mother's assault.
Objection, relevance.
Your Honor, I'm simply laying foundation to the witness's potential bias with law enforcement.
It's overruled.
Thank you. In that experience, would you like me to repeat the question?
Yes, please.
But you also learned that the detectives who investigated your mother's assault were excellent, correct?
Yes.
So they did a good job.
Yes, they did a good job.
And that experience left you with a deep respect for law enforcement, correct?
Yes, a deep respect for law enforcement, but I also value privacy.
Yeah. So you also started Gene Heritage because you wanted people to have the same experience that you had, correct?
Yes.
The same chance to find your family.
The same chance to find my family, to find their family. Yes.
And Gene Heritage is a private company, correct?
This is true.
And the DNA samples you receive are voluntarily submitted.
Voluntarily submitted, that's true.
So meaning people that choose to put their DNA samples into the Gene Heritage.
Yes, this is true.
And referring back to opposing counsel, when they mentioned the law enforcement aspect of it, can you please explain the opt-out version of the opt-out aspect of the Gene Heritage website?
Are you asking me to explain what they have to do to opt out?
No, I'm sorry. Excuse me. Let me rephrase. In order to be able to not be able to have their DNA sample used within law enforcement, they have to check a box that says opt-out, correct?
Yes, and complete a whole separate form.
But they are prompted to have a survey to get their DNA sample removed from that consideration, correct?
Prompted, but it's a fairly lengthy process.
But there is still a prompt that they see on the screen. They have to deliberately choose not to use.
Yes.
Thank you. Moving on. And your company provides meaningful benefits to to its users and its families, correct?
Yes.
Like you mentioned earlier, with your perspective as coming up from your childhood.
Precisely, yes.
Thank you. And you received many letters from families thanking you for helping them solve serious crimes.
Objection, hearsay.
Response?
Your Honor, I'm simply asking to what the witness has simply received in their own present sense.
All right, objections overruled.
Would you like me to repeat the question?
Yes.
You received many letters from families thanking you for helping them solve serious crimes, correct?
Yes, I have. No, I'm done. You can go.
And your core hereditary matching service is free because you want it accessible, correct?
Only the hereditary matching services are free. We also offer enhanced services for additional costs.
Yeah, but the main hereditary matching, which is what the majority of your clients use, is free, correct?
Yes, this is true.
And most of your revenue comes from optional upgraded services, like you just mentioned, like the health analysis and DNA storage, correct?
Yes, most of our revenue, yes.
And these paid upgrades make up about 90% of your total operating budget, correct?
90%, yes, that's right.
And you mentioned earlier, but the law enforcement partnership provided a $15,000 public safety grant, correct?
Yes, $15,000.
But that makes up only 1% of your overall budget, correct?
1% goes a long way.
Yeah. So Gene Heritage does not rely on police partnerships for the survival of the company, correct?
No, we do not.
And Mr. Morales, in order to utilize the Gene Heritage services, you just need to scroll through the entire terms of service in order to continue.
Yes, but you don't necessarily have to read it. Just scroll through.
But you still are prompted to have the terms of service put in front of you.
Yes, that's true.
Thank you. And users, and like I mentioned earlier, users are notified that they can opt out of law enforcement matching when they submit their intake form, correct?
Yes.
So they are prompted and have knowledge that their information is being used for law enforcement.
They are prompted that they are able to opt out, but it's a lengthy process, like I've
There's-
said.
Sorry, they are still prompted. They are still prompted.
Yes.
Yeah. And there's a checkbox for the intake form for opting out, correct?
Yes, and then in a separate form that they have to fill out.
But that checkbox is still prompted.
Yes.
Great, thank you. And when users select that box, they are automatically directed to a separate form that completes the opt-out, correct? Like you just mentioned.
Correct.
And moving on, Moving on, you're aware of a report that suggests high error rates regarding the entire direct-to-consumer market, correct?
Could you repeat that question?
Yeah. You're aware of a report suggesting high error rates across the entire direct-to-consumer market, correct?
Yes, I am.
Yeah, and you reject that report because it only covers a small sample size, correct?
Well, it's 40 companies. That's a whole lot in a business that's relatively new.
Yeah.
In a field that's relatively new.
Small sample size, correct?
But it's a lot for a field that's relatively new.
Yeah. But your own 5-year internal audit revealed a 0.02% error rate, correct?
Yes, these were internal audits that were done with zero third-party intervention.
Which means that 98% of your samples are correct and are accurate.
According to internal audits with no third-party intervention.
That you did yourself.
Yes.
Great. And this is comparable to accredited government labs, right?
For the most part.
Objection calls for speculation.
Your Honor, I'm simply asking the witness a question as to what their business is comparable to. It is well within their knowledge.
Objections overruled.
Would you like me to repeat the question?
Yes, please.
And this is comparable to accredited government labs, correct?
Yes, for the most part.
And you warn law enforcement about contamination risk when you do not collect the original sample, right?
Yes, we do.
And so you provide safeguards and disclaimers to ensure law enforcement uses the results responsibly, correct?
Yes.
So under your system, people choose whether to opt out, correct?
They choose whether to opt out, but it's not necessarily an easy process.
Yeah, but they still have to choose. They have to have that thought in their mind.
Correct.
So they understand that law enforcement can use their DNA if they do not opt out.
If they read closely, yes.
And law enforcement uses voluntarily shared profiles, right?
Can you repeat that question?
Yeah. Law enforcement uses the voluntarily shared profiles, the
Yes.
DNA profiles.
Yes.
And the process has already helped identify perpetrators and victims, correct?
Correct.
Similar to what you have gone through and experienced.
Yes, throughout my life, yes.
And you believe that continuing to allow this cooperation is essential for public safety, correct?
Essential, but I also believe in privacy.
But in order to get the same experience, like you mentioned earlier, that you had as a child, you need to continue to have this company operational.
Yes, but I still don't believe in infringing on anyone's privacy.
Okay. No further questions.
All right. Counsel?
Yes, Your Honor. So tell the court, what inspired you to create your company?
Well, on November 3rd, 2016, I decided to put in my notice at my investment trading job. I instead wanted to reunite families through the use of genealogical testing, considering my personal life experiences.
Now, can you also tell the court, what is the reliability of your tests?
Could you repeat the question, please?
What is the reliability of direct-to-consumer tests?
Well, there was a report that came out that said that the direct-to-consumer DNA market had as high as a 40% error rate. And we expressly indicate that we cannot guarantee the accuracy of results if we did not collect the sample due to things like possibility of contamination during collection, as well as laboratory errors. Further, we advise law enforcement that contamination may indicate that matches exist when, in fact, it doesn't.
And finally, could your opt-out process for this information change in the future?
Well, possibly, with a new law pending in Buckeye's General Assembly that could guarantee an individual's privacy interest in genetic material.
Thank you, Your Honor. No further questions.
Any recross-examination?
Yes, Your Honor. Referring back to what opposing counsel just asked you, can you please, is it correct that the internal audit provided a 99.98% accuracy rating for your company in the DNA samples?
Yes, an internal audit with no third-party intervention.
But still, that was a 99.98% accuracy rating.
Yes, it still was, yes.
Great, thank you. And also referring back to the opt-out process, users are still prompted to opt out of the law enforcement usage of your data.
Yes, they are prompted to opt out, but it, once again, is a lengthy process.
But that is still currently what the website prompts you to do.
Yes, it is.
Great. No further questions, Your Honor.
Thank you. You can step down.
Thank you, Your Honors.
All right, we're going to give you about 2 minutes then to gather your thoughts before we go to closing arguments, okay? All right, is counsel ready to proceed with closing arguments?
Yes, Your Honor.
All right, for the state.
You cannot conceal what justice will do. Justice depends on our willingness to follow the truth, lawfully, carefully, and responsibly. That is exactly what happened in this case. Today, the state has shown a blueprint for what a lawful investigation looks like. Law enforcement did not cut corners. They did not violate the Fourth Amendment. Instead, they relied on information that was lawfully obtained, voluntarily disclosed, and properly used under well-established constitutional doctrines. This case begins not with the police, but with Frankie Moyle. Frankie voluntarily contacted Gene Heritage, created an account, and uploaded their DNA. That voluntary act matters. Once Frankie proved that genetic information, once Frankie provided that genetic information to a private company, Gene Heritage lawfully possessed it. And when Gene Heritage shared that information with law enforcement pursuant to its user agreement, no Fourth Amendment search occurred. Under Schneckloff v. Bustamante, a search authorized by valid consent is constitutionally sound. Frankie Moyle's consent was knowing and voluntary. That consent alone makes the initial use of the DNA lawful under the consent doctrine. But this case does not solely rest on consent alone. It also falls squarely within the third-party doctrine. As Supreme Court held in Smith v. Maryland, information voluntarily conveyed to a third party carries no reasonable expectation of privacy. Originally, law enforcement did not search Morgan Remy. They did not access his body, his home, or his personal effects. They accessed Gene Heritage's database, data lawfully possessed by a private third-party company and voluntarily provided by Frankie Moyle. This distinction is crucial. While the Fourth Amendment protects individuals from unreasonable government searches, it does not prohibit law enforcement from reviewing information that a third party already lawfully holds. The defense has argued that Frankie Moyle lacked the authority to consent to the use of the DNA that ultimately implicated Morgan Remy, but the law does not support that claim. DNA is inherently shared. Family members possess overlapping authority over genetic information because it is not exclusively owned by any single individual. Under United States v. Matlock, consent from one party with common authority is sufficient to authorize a search. And even if this court were to question the scope of Frankie Moyle's actual authority, Illinois v. Rodriguez makes clear that the search is valid when officers reasonably rely on consent the party believe has common authority. Here, that belief was more than reasonable. Frankie was not just the source of the DNA, the account holder, and the individual who voluntarily submitted the genetic material, but he was also a relative of Morgan Remy. They share DNA and therefore have common authority over it. Through this, law enforcement was entitled to rely on that consent. Moving on, importantly, when law enforcement believed they were moved beyond the genealogical lead, they did exactly what the Constitution requires. They obtained a warrant. Morgan Remy's DNA was collected pursuant to judicial authorization, and the result was a 100% match to the DNA found under Caleb Jensen's fingernails. As recognized in Maryland v. King, DNA testing is a reasonable and powerful investigative tool, one that strengthens both accuracy and fairness in the criminal justice system. Detective Saleh has demonstrated today that this was not speculative or shortcut policing. The investigation was reopened based on lawful genealogical match. Adoption records were legally accessed. Corroborating evidence was uncovered. And only then, when necessary, was a warrant sought out and executed. This was careful, constitutional police work from start to finish. Bailey Kim, who you also heard from today, spoke about the importance of genealogical evidence and how it relies on matches from their relative. Then Val Barak from the opposing counsel, Frankie Moyle's classmate, admitted that the extra credit assignment was optional and that the genetic heritage users offered the user choice to share the DNA with law enforcement. They had the choice to not opt in, as well as the fact that they were unable to accept the terms and conditions without scrolling through the entirety of them. They had the choice, but they did not take it. After that, Archer Morales told you about his private company that relies on voluntarily shared information. As an expert, he affirmed that they did have the option to opt out of the law enforcement usage. At its core, this case is about justice. Justice for Caleb Jensen, justice for a family that has waited 25 years for answers. The state has met its burden by a preponderance of the evidence. Frankie Moyle voluntarily submitted their DNA. Gene Heritage lawfully possessed it. Law enforcement acted within the bounds of the Fourth Amendment, and the final decisive DNA evidence was obtained by warrant. The defense asked this court to suppress evidence, not because the law was violated, but because the investigation succeeded. The Constitution does not require that result. The Jensen family should not have to wait any longer. The law was followed. Justice was pursued responsibly. We respectfully ask this court to deny the motion to suppress. You cannot conceal what genes reveal.
Thank you. For the defense.
Yes, Your Honor. Without permission, this case has no vision. Good afternoon. Today, the state of Buckeye has not proved by a preponderance of evidence that the third-party doctrine nor the consent doctrine applies to have allowed them to obtain the Gene Heritage genealogical data. Therefore, the defense respectfully requests that the court grant the motion to suppress. First, the third-party doctrine is inapplicable here. The fact that Frankie Moyo submitted his DNA to Gene Heritage does not overcome Morgan Remy's right to Fourth Amendment protection. As held by Carpenter versus United States, when an individual seeks to preserve something as legitimately private, and the expectation is one that society is prepared to recognize, intrusion into the sphere qualifies as a search and requires a warrant. Genealogical information fits squarely into this category. This is distinguishable from the matters discussed in Smith versus Maryland, in which business records were exchanged in an ordinary course of action. In contrast, DNA never leaves a person's ownership, cannot be transferred to be owned by a third party, and is certainly not exchanged ordinarily. And the government recognizes this through statutes like HIPAA, which limit how health information can be distributed. In addition, we see with House Bill 12 that society recognizes genealogical information as legitimately private, or else they wouldn't even be considering adding privacy stipulations to companies like Gene Heritage. We also see that Val Barak did not complete the assignment due to privacy concerns, and Frankie Moyo's adoption records, in other words, genealogical relationships, were sealed and a warrant was required to unveil that information. In this case, we must conceal what genes reveal when it comes to the protection of constitutional rights. As explained by Archer Morales, as well as a disclaimer by Gene Heritage, DNA is not always accurate, and we see up to a 40% error rate with companies such as Gene Heritage. We cannot allow this information to be used, especially when it violates the constitutional rights of Americans. Second, Frankie Moyo did not voluntarily consent to the use of his genetic information by law enforcement. As explained by Archer Morales and Exhibit C, Gene Heritage operates under an opt-out policy rather than an opt-in. This policy is unreliable and misleading, allowing innocent people's DNA to fall into the hands of law enforcement without their consent or knowledge. Schneckloff versus Bustamante held that a search under the Fourth Amendment requires a warrant unless voluntary and knowingly consent is given. Val Barak explained that Frankie Moyo did not knowingly consent, as he said himself he did not read the terms and conditions carefully. Valbarock had to print, highlight, and underline the terms and conditions of Gene Heritage in order to find this hidden opt-out policy that she agreed is unreliable and misleading. Frankie Moyo did not voluntarily consent to the use of his DNA by law enforcement. Therefore, it is unconstitutional due to the Fourth Amendment. DNA is not just data. It's our biological blueprint, revealing every aspect of who we are, where we came from, and who we are related to. Submitting an extra credit assignment does not give law enforcement permission to use that information for their own good, especially considering we see that DNA is recognized by society as legitimately private under several statutes, as well as the fact that Frankie Moyo did not knowingly consent as he did not read the terms and conditions carefully. So, all of this considered, we ask the court today to grant the motion to suppress the genealogical Gene Heritage data, as the prosecution has not proved by a preponderance of evidence that the third-party doctrine or the consent doctrine applies to have allowed them to obtain this data. Without permission, this case has no vision. Thank you.
Thank you. Is there any rebuttal?
Yes, Your You cannot conceal what genes reveal. This trial is about a motion to suppress. Opposing counsel has argued that the privacy comes first. However, the law does not back this up. Under the third-party doctrine and the consent doctrine, this was not a violation of Morgan Remy's Fourth Amendment right. Frankie Moyo voluntarily submitted his evidence to Gene Heritage website. He was prompted to read through the entire terms and conditions, yet he did not. He scrolled through them, but he did still have to be prompted, and he voluntarily chose to accept those terms and conditions. He also was prompted to opt out of the law enforcement usage, where he also did not. He voluntarily chose to have his information used by law enforcement. Today, we have heard a lot of evidence from a lot of different witnesses. We heard evidence from Ronan Solly, who highlighted the lawful investigation that he conducted within this case. At times, Gene Heritage legally had the DNA provided to the police. This is a third-party company that lawfully obtained Frankie Moyo's DNA, which was then obtained by the police through the third-party doctrine. The police followed the letter of the law. Frankie Moyo volunteered their DNA to Gene Heritage, and they would do so again today. It's time to put this cold case to rest. Deny the motion to suppress. Thank you.
Thank you. All right, the scoring judges can retire to begin scoring. I'll remain here for a couple of minutes to see if there are any material objections to the evidence that was presented.
We don't have any objections, Your Honor.
The defense has no objections either.
All right, we will be back. All right, gang, excellent job. That was one of the better all-around presentations that I've seen in the years I've been doing this. Both teams, all 4 attorneys were excellent. All 4 witnesses were excellent. It was, we're going to award in a little while the outstanding attorney and outstanding witness, but it was razor thin all the way around. So congratulations. You all had a great grasp of the materials, and I liked the way generally everything was presented. The witnesses were entertaining. Good. Everybody had good eye contact. It was just really one of the better ones that I've seen in the dozen years that I've been sitting up here doing this. So congratulations on doing an outstanding job. And I have one comment at the end. I'm going to turn it over to Judge Patton.
Thank you. Closer than the last one. And I know it sounds like a throwaway line, but you both teams did an excellent job. A couple comments. One is when, I think both sides did this, when you're doing cross, you may want to mix up the form of the question, not end with correct at the end. You can say, wouldn't you agree? Isn't it fair to say? I think one of you started the cross with, you're here to answer yes or no questions. I wouldn't necessarily do that. I wouldn't tell them, I would force them to just say in advance, I'm going to ask you direct questions or cross-examination questions. And then when they start off, you could say this is cross-examination. Yes or no, please. That type of thing. I wouldn't necessarily announce that at the beginning. The one question that I had is there was a theme that was mentioned twice during your opening, and then you mentioned it in close about the case has no vision. I'm not sure that, I know you're trying to put a theme. I'm not trying to be overly critical. I'm not sure what that means. Like, what does it mean when you say the case has no vision? You may want to tweak that a little bit, just because I don't know that whether it's about having vision. I mean, what the essence of the case is that this person this relative gave the DNA, and now it led to your client now having this problem with being charged with a murder. I might want to change that a little bit. I just don't. That didn't resonate with me, just in a constructive way. For the witnesses, they just kept getting better and better. So I know that Mr. Hart, I saw you last year. You did a great job last year. I think your hair was longer last year, if I remember. But you very much embrace your role, your character, and I remember, I think separate and apart, you did a great job today, but I remember you from last year just because you made an impression, a favorable one. So I'll turn it over to my colleague.
Okay, I'm Terry. I had such a great time today. I love the content that we talked about. I've been practicing criminal law for over 19 years. I've been doing mock trial for probably 15 or more of those years, and I thought today we had some of the best back and forth that I've seen in a long time. So thank you for making this such a great afternoon for us. I love themes. I love that you guys incorporated the themes. I do agree, I don't think your theme is as strong. I also don't think, in these terms, your case is quite strong, quite frankly, and not that you have to work with what you're given, and sometimes it's made that way, but I completely understand what you're saying, but I love the themes. I thought everyone had a fantastic use of exhibits. We had a lot more use of exhibits than we had this morning, and I was really impressed by the way you used the exhibits and how many exhibits you were able to use. And I thought everybody was really appropriately passionate this afternoon, and we didn't see as much of it this morning. It wasn't, you weren't overly passionate, but you understand the importance of this and that it can have broader implications, so I really enjoyed the intensity I got of the presentation of the cases today. One thing that I want to talk about specifically is opening statements.
I think in both of the opening statements today, and actually both of the opening statements we had this morning, one particularly more than the other, opening statements are statements and not called opening arguments for a reason. You are here to give a roadmap of what we're going to hear. And in real life, when we're talking about suppression hearings, I know it's a little bit different because it's not the same as presenting a trial where you come up and you say, here's the story you're going to hear, and here's my witnesses who are going to explain it to you, because you are setting forth the standard to the court that then these witnesses are going to get to you. And I think what happened with this case for some reason is it would be appropriate to come up and say, here are the factors, or here's what we're going to prove, and here's how my witnesses are going to connect you to that. But when you start arguing and you start talking about case law, you have gone into a closing argument and you are off of the path of what we want to see, particularly under the mock trial rules for an opening statement. So be mindful of that, particularly if you're moving on. You guys both went well beyond what I would have wanted to see for an opening statement. When you start to argue, and this is why you should rule for my client, and it is beyond a statement that you're trying to make. Add that in your closing argument if you have to. Witnesses, you guys were so fantastic, all of you across the board. I thought you were great, and there is a lot of scientific information and evidence that you need to be aware of. Very specific language that we're looking for, and I was really impressed that you guys were able to recount that. And then I'm just going to say, who said? Ronan. As soon as you said it's impossible to be completely accurate, I think that my crime lab analyst would disagree with you on that. Just a final comment there.
All right, just a couple things before we do the outstanding witness and outstanding attorney. The back and forth on the objections was really good by all you guys. There was some quick thinking going on there. So you listened to what the other person said, and then you actually responded to it, which was above and beyond what's usually seen. So that I forgot to mention that before. Terry mentioned about the opening statements. Since I've been here, I've probably done 100 jury trials. And every time before I start, I tell the lawyers the opening statement is an opening statement. It's not an opening argument. It's a common thing that occurs. So just so you know that people that have been doing this 20 years, trials, do the very same thing. It's just something that you have to get used to and be mindful of. I think it was Ms. Goldberg who, when Ms. Carnes got up to do cross-examination, I think you indicated you were going to ask some questions, and to the effect of, please listen to answer the questions, and you gave a great answer. I'll answer as I please. I thought that was great, because you should be trying to answer to get your point across on cross-examination.
Reagan, were you the one that
Yes.
please answer yes or no?
Yeah. And then she said, I'll answer as I please.
It makes it seem, I think it weakens you as a person, because you're saying, you're already setting these guidelines. You know she's not going to follow them. Use effective control techniques as opposed to saying, she's never going to do what you said. I think it makes, as an attorney, I think it makes you look a little bit weaker going forward. It's the same, I feel the same way about when someone says to the judge, can you make them answer my question? Those are two things, like, you need to take that control on yourself, and I think that those are two ways it makes you seem like you're less in control of your witness.
You could always say, let's try this again.
Or you misunderstood my question.
Or you could say, all right, how about answering my question? This is cross-examination. I asked you a simple question. Yes or no? Do you understand my question? You can belittle and be a little nasty with it.
To a certain point, and then I step in and tell you to knock it off.
But until he says knock it off, as the trial judge, I'll say, do you understand my question? I'm asking you a very simple question.
I'm sorry, I must have confused you.
Right.
Turn it around on them. Don't take that power away from yourself.
Right.
Although if you're doing a jury trial, it becomes a matter of you not wanting to convey to the jury that you're a pompous ass and that you're belittling somebody to stepping over that line. So It is a fine line that you gotta be careful
But
with.
if they're playing games, the jury will see that.
If they're here and they're playing games, I'm stopping it pretty quick and telling them to answer the question.
Right.
And knocking that nonsense off. One final point on the themes. I like that you have themes. And the prosecution's theme was, you can't conceal what genes reveal. And then I thought Reagan had an outstanding statement in her closing argument. We must conceal what genes reveal. So I thought you played very well off of that. So that was a matter of kind of quick thinking as you go along here. But overall, once again, great job.
Yeah, because that was like an audible, you took their argument and used it against them. Their theme and used it against them. One last thing, in the opening statements, just think about the evidence will show. Even if you don't say it out loud, just say the evidence will show. I mean, you're giving a preview as to what you think the evidence will be while presenting your theory of the case. That's not necessarily an argument. You're providing some context for the judge to understand what's going on.
All right, so now we have the outstanding witness and the outstanding attorney.
Yes.
Judge
so
Patton with the outstanding witness.
Tommy Hart, great job. There you go.
Our outstanding attorney is Megan Hart.
All right, thank you very much, folks. If you want to stick around and talk to us, we'll be out here in a minute. Otherwise.